Present. Without objection, the chair is authorized to declare a recess at any time.
Mr. Chairman, point of inquiry.
Pursuant to
Mr. Chairman.
Rule 2 and House Rule 11,
Mr. Chairman, it's emerged over the last 24 hours that from an FBI whistleblower that the Counterterrorism Division of the FBI is threat tagging parents of school children.
gentleman is not recognized. Pursuant to Committee Rule 2
Mr.
and
Chairman,
House Rule 11,
It calls
Clause
into
2,
question whether or not
Chair may
the Attorney
postpone-
General lied to this committee on
gentleman
October
is not
21.
recognized.
Mr.
Gentleman
Chairman,
is not recognized.
very politely,
Pursuant
this
to
is a very
Committee Rule
important
2 and
topic
House
that
Rule
we're
11,
going to be
Clause
covering
2,
today,
the
but we
chair
have
may-
a pressing issue
Committee,
that we need to
the
deal with right
gentleman
now.
is not recognized.
Mr. Chairman, would you
Pursuant-
please recognize me? Because
No, not now.
this will just take a
Pursuant to
few
Committee
minutes,
Rule
and then we'll get on to this very important topic of
At
today.
the appropriate time,
Mr.
you'll be
Chairman.
at the appropriate time, you'll be
Chairman.
recognized.
Mr. Chairman.
Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered.
Mr. Chairman, it's
would like
time to
to-
bring Attorney General Garland back into this body.
The gentleman is not recognized. I would like to remind members that we have established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible. I would also remind all members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, excuse me, such as committee markups, except when recognized to speak. Finally, I would ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4445 to amend Title IX of the United States
Without
Code.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Yesterday, this committee heard powerful testimony from 4 survivors of sexual assault and sexual harassment about their harrowing experiences and the deep wounds they continue to carry with them to this day. It was a hearing none of us will forget, and we appreciate these brave women coming forward and sharing their stories. As they explained, after enduring such horrific trauma at the hands of their perpetrators, they were forced to endure further trauma when they sought to hold their assailants accountable in court and found that their only recourse was a secretive arbitration process that was stacked against them. Arbitration was originally developed as an alternative to the court system for parties of relatively equal bargaining power to enter into voluntarily. In recent decades, however, forced arbitration clauses have become ubiquitous in our lives, largely in the form of take-it-or-leave-it contracts between very large companies and individual consumers. As a result of this trend, these clauses have rendered our court system, in which victims have far stronger protections, inaccessible to far too many. Nowhere is that trend more apparent or problematic than in the workplace. It is projected that by 2024, 80% of private sector workers will be forced to sign an arbitration clause when accepting employment, a full 80% of our fellow citizens. And consider that, over the past 5 years, employers prevailed over their employees in 98.1% of these arbitration cases. Buried deep in the fine print of the paperwork, these employees were required to sign. They bound themselves to a system in which they are nearly guaranteed to fail. They foreclosed the possibility of ever having their day in court, and in nearly all of these instances, they even gave up the right ever to talk about their experience. But these numbers cannot capture the true human toll of forced arbitration. Earlier this year, the Subcommittee on Antitrust, Commercial, and Administrative Law held a hearing examining the effect of forced arbitration clauses on our fundamental statutory rights and protections. There, Gretchen Carlson, who survived pervasive sexual harassment by Roger Ailes, the CEO and founder of Fox News, testified about the use of forced arbitration to silence victims of systemic sexual harassment. Professor Miriam Gillis of the Cardozo School of Law similarly explained how forced arbitration perpetuates the exploitation of women in the workplace by shunting victims into a private system where each is unaware of the other and where the arbitration provider, who is chosen and paid by the employer, lacks authority to remedy systemic and recurring workplace abuse. As Ms. Zandoa Newton testified yesterday, no aspect of the contract with her employer was actually negotiable, including the forced arbitration clause. As a result, she was forced into an opaque system that limits discovery, does not include the protections of the federal rules of evidence, and leads to secret rulings without oversight or scrutiny. By forcing her and others into silence, by denying them the option of seeking their day in court, forced arbitration allows toxic office cultures to flourish and embolden sexual predators to operate with impunity. In a system that sides with the company 98% of the time, accusations of sexual assault will remain hidden forever. The company gets to pick the judge and the jury, truncate the discovery process, choose the law applied, and prevent all appeals. When the company wins, it can request that the victim pay its attorney's fees. H.R. 4445, the Ending Forced Arbitration of Sexual Assault and the Sexual Harassment Act, removes these barriers to justice for survivors of sexual assault or sexual harassment by giving them a real choice of whether to go to court or to arbitrate their claim. In doing so, H.R. 4445 ends this unjust and frankly repulsive system in which American companies are seemingly better off retaliating against victims of sexual assault than taking responsibility and holding the perpetrators to account. This legislation is supported by a broad coalition of public interest organizations, including the National Alliance to End Sexual Violence, the National Center on Domestic and Sexual Violence, the National Coalition Against Domestic Violence, the National Partnership for Women and Families, the Rape, Abuse, and Incest National Network, and many others. Earlier this month, the Senate Judiciary Committee passed identical legislation through a unanimous voice vote with overwhelming bipartisan support. Now we must do the same. I thank my colleagues, Representatives Bustos and Jayapal, for their leadership on this issue, and I urge my colleagues to support this bipartisan legislation. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. On October 21st, the Attorney General of the United States was in front of this committee and made this statement, quote, "I could not imagine any circumstance where parents are labeled domestic terrorists." One problem with that statement. The day before he said that to this committee, the House Judiciary Committee, the day before, there was an email sent to FBI agents around the country stating just the opposite. Email sent from the Counterterrorism Division of the FBI, treating parents, labeling parents, categorizing parents as a threat tag for simply showing up at school board meetings and speaking their mind, objecting to a racist, hate America curriculum. They're getting labeled, and we know this because of a brave whistleblower who came forward 24 hours ago. We have this information. And if the gentleman from North Carolina, my colleague, Mr. Bishop, had been able to make his inquiry of the chairman, was not recognized by the chairman, even though this happened, even though it calls into question whether the Attorney General misled the House Judiciary Committee with his comments that day. If he'd have been recognized, he was also going to point out that he had sent a letter to the Justice Department asking, what have you done as a result of that October 4th memo? No answer. We know what they did. They sent out this email to FBI agents saying spy on parents. But you wouldn't even recognize him. You wouldn't even recognize him. I mean, this scenario where on September 29th, a left-wing political organization writes the President of the United States saying, we want you to get the FBI involved in spying on parents, setting up a dedicated line of threat communication, a snitch line on parents. 5 days later, a memo goes out. He comes and testifies, looks like he said something that wasn't true to this committee. And the very next day, think about this, I've never seen this in all my time in Washington. The very next day, the organization that started this whole thing in progress, they apologize for the initial letter that started it all. They withdraw the letter. And you guys won't join us in wanting to, we need the Attorney General back sitting right at that chair answering our questions. And you wouldn't even recognize the gentleman from North Carolina. I hope I hope the majority understands how serious this is. You know what this reminds me of? This reminds me of something we all went through 10 years ago. This reminds me of when the IRS targeted people, and then it wasn't called a threat tag, then it wasn't called a terrorist tag, no, then it was called the BOLO list, be on the lookout list. If you said the wrong thing in this country, the IRS, Lois Lerner, the IRS puts you on a list, much like what we see the FBI doing now, thanks to this brave whistleblower who came forward. So we're going to discuss some of that issue today as well, Mr. Chairman. And I know we have an important piece of legislation in front of us. And I again want to say thanks to the people who came yesterday and testified. It was compelling and powerful. No one should ever feel the way those victims felt, that they had been wrong, they had no real recourse. The expert testimony we heard yesterday, that arbitration is generally a well-functioning mechanism for dispute resolution, was also important. The analysis we heard from Ms. St. John, Ms. Parshall Perry helped to illustrate that to the extent there are problems with arbitration, we should fix those problems. That does not mean undermining a system that in most instances and for most types of claims provides a faster, more affordable, more efficient resolution to disputes. I said it yesterday, though, a right without a remedy is no right at all. In America, everyone deserves justice, and I don't think anyone who heard yesterday's testimony could argue that those victims got justice or that they were treated fairly. We all understand that. But some of us are concerned about how this legislation goes about accomplishing that and the consequences that it could have to a dispute resolution in general. This legislation does more than just change how a specific set of claims might be treated. We have a handful of amendments that we plan to offer today on the arbitration legislation, and we will do that, but we're also going to talk about what we learned less than 24 hours ago, what the Justice Department is doing, how they are treating, how they are categorizing, how they are labeling moms and dads. That is of critical importance, and the fact that the Attorney General said something that is directly contradicted by the email that went out the day before he said what he said to this committee, and we now know from this whistleblower, I think should be of paramount concern to this committee. With that, Mr. Chairman, I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 4445, offered by Mr. Nadler of New York. Strike all after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment makes two changes to conform H.R. 4445 to its Senate companion S-2342, as reported out of Senate Judiciary Committee. First, it clarifies that the legislation is operative at the election of a person who alleges conduct that constitutes a sexual harassment or sexual assault claim. In doing so, the amendment makes sure that there is real choice as to whether to file these cases in court or in arbitration. Second, the amendment clarifies that the legislation applies in all relevant disputes. The Senate Judiciary Committee passed this legislation by a unanimous voice vote with strong bipartisan support several weeks ago. As Senator Grassley said in support of the bill, all victims of sexual assault or sexual harassment deserve to have their voices heard and to have the option to go to court if they so choose. Mandatory arbitration shouldn't be enforceable in these cases. Under the bill, individuals who want to arbitrate their claims will still be able to do so. I strongly agree, and I urge my colleagues to support the amendment and this bipartisan legislation. Are there any amendments to the amendment in the nature of a substitute? For what purposes does Ms. Jayapal seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you for bringing H.R. 4445, the Ending Forced Arbitration of Sexual Assault and Harassment Act, before the committee today. I am so proud to co-lead this bipartisan, bicameral bill with my fantastic colleague, Congresswoman Sherry Bustos, as well as Congressman David Cicilline and Congressman Morgan Griffith, which preserves the right for sexual assault and harassment survivors to choose how they seek justice for the wrongful treatment they endured. I also want to acknowledge that we have with us Gretchen Carlson today, who has been a phenomenal champion. Ms. Carlson, I just want to say that courage begets courage, and your voice has meant so much to millions of women across this country. Yesterday, the committee heard the personal stories of 4 women who have been impacted by forced arbitration clauses in their employment contracts. I am incredibly grateful to them for their bravery and resolve to make it clear what we are talking about today. These courageous women are just a few of the hundreds of thousands of people, including people who are transgender and queer, as well as men, who are impacted by pre-dispute forced arbitration for assault and harassment claims. For example, thousands of former employees of Sterling Jewelers, the company behind Kay Jewelers, suffered from sexual assault, harassment, and discrimination in the workplace. Hundreds of employees provided personal accounts of inappropriate conduct over the course of their employment. But Sterling Jewelers used forced arbitration to hide a class action lawsuit, which has grown to include around 70,000 women from the public eye. Corporations often condition their services and employment contracts on an agreement to be subject to pre-dispute arbitration. These agreements require people with disputes against a company to use out-of-court mediation, not the judicial system. As a result, sexual assault and harassment survivors with claims against a company are stripped of the right to decide how to pursue accountability for their perpetrators. Their claims are funneled into a secretive, one-sided process which denies justice and does nothing to stop widespread systemic abuse from occurring in the future. If you doubt that these voices have been silenced or that forced arbitration just perpetrates that silence and the culture of violence, then consider what happened after Tatiana Spottiswoode courageously testified yesterday. Because of her testimony, because she brought light to what happened to her and the abuse that she suffered, the former Prime Minister David Cameron, who was serving as the chairman of Affinity's board, has now stepped down. That is the beginning. It is not the end, but it is the beginning of the accountability that is required. Forced arbitration is a rigged system. HR 4445 would eliminate the system by invalidating forced arbitration clauses for sexual assault and sexual harassment claims, preserving the right of survivors to hold companies publicly accountable in court, and providing the opportunity for survivors to gain real relief. HR 4445 is essential to our justice system. Moreover, it pushes the needle forward on eliminating forced arbitration so that workers, consumers, and small businesses have a fighting chance in our justice system. We must not only pass HR 445, but I hope that we also pass HR 963, the FAIR Act, which would ban forced arbitration clauses, restore choice, and allow corporations to be held publicly accountable for their actions across the board. I am also so proud, and again, I thank my colleague, Congresswoman Bustos, who was out of the room when I acknowledged you. I just wanted to say how wonderful your work has been in making this a bipartisan, bicameral bill. This essential legislation preserves the right of sexual assault and harassment survivors to use their voices and speak out against abuse. No person should be deprived of their right to choose how their voice is heard. I am proud to support this bill, and I encourage my colleagues to vote yes. And Mr. Chairman, I'd like to, I seek unanimous consent to enter into the record a letter from Representative Bustos on the importance of this bill.
Without objection.
Thank you, Mr. Chairman. I yield back.
The gentlelady yields back. For what purpose does Mr. Johnson of Louisiana seek recognition?
Thank you, Mr. Chairman. This is an important issue. We're grateful for the testimony of the witnesses.
The gentleman desire to strike the last word?
Strike the last word.
Gentleman is recognized.
We're grateful for the compelling testimony of the witnesses yesterday, and grateful to Ms. Carlson and everyone who's worked on this issue. But before we get to that, we have to address the most pressing and most immediate issue that is before this committee. We have a broad jurisdiction. Among our jurisdiction is the oversight of the Department of Justice. The highest ranking law enforcement official in America testified before us on October 21st. Yesterday, a whistleblower document reveals that the FBI's Criminal and Counterterrorism divisions added a threat tag to parents who protest or express their concerns about local education policies at local school boards. Why is this so noteworthy? Well, this now leaked October 20th internal memo gave that directive. Obviously, treating concerned parents as domestic terrorists is outrageous. We're deeply concerned about that. But this development is even more urgent because the Attorney General appeared before us Merrick Garland, he specifically testified the day after this directive was issued, it was October 21st. He said repeatedly and under oath that the Department of Justice is not targeting parents. In fact, as Ranking Member Jordan said just a moment ago, here's just one quote from his testimony. He said, Attorney General Garland said in his own words, "I cannot imagine any circumstance in which these parents would be labeled as domestic terrorists." But this disclosure from the DOJ whistleblower calls into question the accuracy and the completeness of that specific testimony. Did the Attorney General mislead us? Or did he actually not know what the two largest divisions of the Department of Justice are doing about one of the highest profile issues in America today? There are only two possibilities here. He's either dishonest or he's incompetent. And either scenario is of great alarm to the American people. I have a letter that I sent to him November 2nd following that hearing because one of the issues that he was not forthcoming about was his family's financial interest in the very issue that he directed the Department of Justice to go after. And I said in this letter, by any objective measure, your answers to very simple and direct questions during our hearing were inadequate. And it is thus our obligation as the Judiciary Committee to again request information to determine whether you met your ethical obligations as our country's top law enforcement official when you issued that October 4th memorandum, where he sicked the Department of Justice, U.S. attorneys and FBI agents on parents for showing up and engaging in their First Amendment right to weigh in on their children's curriculum and what's happening. And of course, his son-in-law, as we pointed out, and as the records reflect, directly relates to this. He has direct financial interest in pursuing critical race theory curricula and other materials that the parents are going to protest. So the highest ranking law enforcement in the country weighs in on it, sicks the full weight of the Department of Justice against parents who are protesting the very materials that his family is profiting from. The Code of Federal Regulations discourages executive branch officials from engaging in conduct, I say in my letter, reminding him, that is likely to affect the financial interest of, quote, a person with whom he has a covered relationship. The Attorney General has not addressed this issue, and now, because of this leak, we have good reason to believe that he misled us, not only on that, but on all the issues that he testified to. The main issue of the hearing, from our perspective, and this is of great concern. So we insist that the Attorney General return to this committee, that we put him under oath again, and we get answers to these critical questions, because as I explained to him in that hearing, and we all know, the American people are losing their faith in our institutions, and if they lose their faith in the idea that justice is blind, that there are not two standards of justice, there's just one standard, and no one is above the law, if we lose our belief in that standard, in that principle, then we lose something that is essential and fundamental to holding our republic together. That's what's at stake. And the importance of that issue transcends everything else that we have to do today. Everything, in my view, everything we have to do in this Congress for the remainder of the year. We have to get the Attorney General on record to clear this up. The American people are owed that, and we will not cease in insisting upon that. And Mr. Chairman, I beg you to do your job, do our job as this committee with this important oversight responsibility and bring back the Attorney General. With that, I yield back.
Gentleman yields back. For what purpose does Mrs. Cicilline seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. Predators rely on silence. As long as their actions are hidden, they are free to act with impunity. And forced arbitration, when weaponized by sexual predators in the workplace, creates a culture of silence. These clauses are ubiquitous in everyday contracts and block survivors of sexual harassment and assault from making their stories known and having their day in court, preventing them from holding abusers accountable for their horrific crimes. This private system does not have the same procedural safeguards of our justice system. It's not subject to oversight, it has no judge or jury, and it's not bound by laws passed by the Congress or the states. And when forced arbitration is combined with non-disclosure agreements, as it so often is, it silences the survivors of sexual harassment and assault. For example, according to a disturbing report by the Washington Post, hundreds of former female workers of Sterling Jewelers, the massive jewelry chain that owns Kay Jewelers and Jared, were, and I quote, routinely groped, demeaned, and urged to sexually cater to their bosses to stay employed, end quote. According to numerous sworn statements, male executives and supervisors at all levels of the company engage in a widespread pattern of abuse, harassment, and discrimination. This misconduct included forcing women to perform sexual favors, to receive better jobs or higher pay, and retaliating against women who reported abuse within the company. One store manager wrote in her declaration that male executives, and I quote, prowled around like dogs that were let out of their cage, and there was no one to protect the female managers from them, end quote. Although many of the women at Sterling Jewelers sought to hold the company accountable by banding together in a class action, Sterling covered up this abusive conduct for years by forcing its workers to waive their right to bring a lawsuit against the company in public court. These arbitration proceedings were conducted in private. The outcome was sealed, and any settlements with the company were bound by confidentiality clauses. Not only did this massive cover-up shield the company from public accountability, it also blocked other victims of assault and harassment from coming forward until some of the stories finally became public years later. As Gretchen Carlson testified during my subcommittee's hearing on forced arbitration in February, and I welcome her here today again, these are not isolated cases. Far from it, thousands of women across the country have suffered through similar pain and humiliation. They were isolated and taken advantage of. They were silenced by forced arbitration clauses and non-disclosure agreements, and they were unable to hold wrongdoers accountable by having their day in court. As Ms. Carlson testified, forced arbitration, and I quote, perpetuates the systemic problem of protecting predators, end quote. Yesterday, we heard directly from several survivors of this abuse, Ms. Newton, Ms. Spottiswoode, Ms. Henry, and Ms. Dushku. And their testimony illustrated how this outrageous practice is routinely abused by predators to cover up their horrendous behavior. As Ms. Spottiswoode made painfully clear in her testimony, her abuser, the founder of Invisalign and the CEO of Affinity, initiated an arbitration against her because he knew the secrecy of arbitration would protect him after beating and sexually abusing her. H.R. 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, will end this heinous practice once and for all. This bipartisan legislation prevents forced arbitration for any claim of sexual assault or sexual harassment. I'd like to thank you, Chairman Nadler, for considering this bill today, as well as my colleagues, Representatives Bustos and Jayapal, for their leadership on this issue. The companion to this bipartisan legislation was passed unanimously by the Senate Judiciary Committee several weeks ago. I urge my colleagues to support this measure today. And for anyone who had the privilege of hearing the testimony yesterday of the survivors of this conduct, let's show the American people that we're going to respond in the right way and have every single member of this committee vote yes so that we can send a strong message to anyone who would contemplate engaging in that behavior that they will not get away with it. That the time for forced arbitration clauses that provide that kind of secrecy is over. And with that, I yield back, Mr. Chairman, and urge everyone to support this legislation.
The gentleman yields back. For what purpose does Mr. Bishop seek recognition?
Strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. And I'm going to try to squeeze in here, or perhaps on yielded time if I don't get it all done, because I want to have a constructive engagement on this bill. I want to support this bill. But there's a very substantive inquiry I need to make about it. I hope someone on the majority side will be willing to engage with it. But the first thing I'm going to do is attempt to get out some of what the chairman would not entertain as a point of inquiry about the need for Attorney General Garland to return to this committee. And here's what I want to add to what has already been stated. Well, let me recap a couple things. It is the last 24 hours since a whistleblower has brought forth an email from the Counterterrorism Division of the FBI talking about threat tagging incidents where these parents are protesting against school boards. If that does not shock everybody on this committee, you've been in Congress too long. And so here's the other thing. That document that had to come out from a whistleblower was sent on October 20, the day before Attorney General Garland testified before us. That document should have been in our hands when we asked Attorney General Garland questions. Because on October 7, immediately seeing that October 4 memo from the Attorney General was breathtakingly problematic, I sent a letter and said, I want to see all correspondence within the Department of Justice connected with or relating to that October 4 memo. It should have been sent to my office the same time it was sent to the FBI. And believe me, there would have been questions to Attorney General Garland based on that. Not only is there a question about whether Attorney General Garland denied knowledge he must have had when he testified to this committee, but that memo was out. It was disturbing enough to an FBI agent to become a whistleblower. It should have been in the hands of Congress. This is a cover-up at the Department of Justice. Now, as to where we are in this bill, here's the problem that concerns me about the bill, and I otherwise will support it if this is fixed in some way. There is a definition, gosh, I hope I haven't paged away from it. There is a definition of sexual harassment here that is new to the law. Anyone who's practiced in this area knows that sexual harassment, the definition of sexual harassment is actionable under federal law, under Title VII, has been dealt with very comprehensively and carefully by the Supreme Court of the United States. In the Harris versus Forklift Systems case in particular, Justice O'Connor made clear that it must be sexual harassment is actionable if it is sufficiently severe or pervasive to alter the conditions of plaintiff's plaintiff's employment, and that requires that it be an objectively hostile or abusive work environment that's created when a reasonable person would find it hostile or abusive, and the victim subjectively perceives it as such. Now, that's been the law. Harris has been the law since 1994. It's based on Meritorious Savings Bank, which has been the law since '83. Upending that is very concerning. The definition of sexual harassment dispute here that gets exempted, carved out, and would be pre-employment arbitration agreements unenforceable, includes, without any definition of that, without any language relating to the standard of the severity, whether it has to be offensive to a reasonable person and so forth. It simply says, for example, one of the things in there is unwanted sexual attention, including unwanted sexual comments and proposition for sexual activity. This leaves open the possibility, it seems to me, that you're ditching the reasonable standard test, so it could be as subjective and as varied as the variety of people in the United States. Is it intended to dispose of that standard? And if not, why is it done this way? And I'm about out of time, but I hope that someone on the majority side will, yes, I'd certainly yield.
Thank you. I believe you're referring to the sexual harassment dispute section of the bill.
I am.
Correct. So I just want to clarify that that does not in any way change existing law. It says that in order to get into discussing that dispute, that it's just saying that this is what constitutes a sexual harassment dispute to move forward with your claim. It does not in any way change the law, and I'm sure we'd be happy to rectify that by saying in the, somewhere, not necessarily in this bill, but in the definitions of this, that this is not intended to in any way change the law. This is just about moving forward. So
my time's expired. Perhaps we can refine this in further. I appreciate it, Ms. Jaipa.
The gentleman's time has expired. Mr. Jones.
Thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized.
I also want to thank Chairman Cicilline and Representative Jayapal for introducing this vital legislation. Yesterday, we heard powerful testimony of 4 survivors of sexual harassment and assault. Eliza Dushku, Laura Henry, Andawa Fawn, Ann Newton, and Tatiana Spottiswoode. Long silenced by exploitative contracts, these courageous women were only legally permitted to tell us their stories because they were under subpoena. Finally free to speak out, they had one simple request of us: that we restore survivors' access to justice by ending the forced arbitration of injustices like those they experienced. I'm proud to support this legislation today because it's long past time for us to heed the calls of survivors. It is the least that we owe them. And it is a critical step towards building a legal system that is worthy of being called a justice system. For decades now, corporations have exploited their power over our economy and our democracy to require consumers, workers, and small businesses to resolve disputes with them through binding one-on-one secretive arbitration. under rules written by corporations for the corporations. Thanks to years of 5-4 decisions by the far right majority on the Supreme Court, forced arbitration has become inescapable, even when the civil rights and basic safety of survivors are at stake. Nearly every American is subject to at least one forced arbitration clause. Over 55% of non-union private workers, in other words, over 60 million people, are forced into arbitration by their bosses. Even though forced arbitration is inescapable, it is largely invisible, because arbitration clauses are written in legalese and buried in long take it or leave it contracts. 2/3 of Americans have no idea they consented to arbitration when they started a job, took out a student loan, or went to the hospital. And make no mistake, forced arbitration is indeed forced. Survivors should not have to endure the insulting insinuation that forced arbitration is somehow their own fault, that they somehow agreed to forced arbitration freely and fairly. When forfeiting your rights is the only way to get or keep a job, as it is in today's economy, then you do not have a real choice. Let me emphasize this for some of my Republican colleagues whose comments yesterday were at times disappointing. If your response to a survivor seeking justice for sexual assault is to deny them justice because they consented to arbitrate, then you are blaming the victim. It is that simple, and it must end. In any event, it should be no surprise that when we let corporations create their own legal system, they put themselves above the law. Without the opportunity to have their day in court or to bring claims as a class, the American people cannot afford to protect their rights. Almost no one even tries. And that's not hard to understand, because when people try to arbitrate, they lose. Employees prevail against their employers just 1.6% of the time. More Americans are struck by lightning each year than win damages in forced arbitration. And in the incredibly rare cases when the people do prevail, they win less than they would if they had their day in court. In arbitration, winning employees and consumers won a median arbitration award of $36,500. In state court, that number is $86,000. In federal court, it's $176,000. So the survivors yesterday did not ask us to fix forced arbitration. They asked us to end it. To answer their call today, we need only summon a fraction of the courage that they showed us. And let me just end on this note. We've seen a lot of low behavior in this committee this year, but very few things compare to distracting from the very harrowing experiences shared with us yesterday, and the important work that we are doing to make sure that that doesn't happen again by leveling spurious allegations against the Attorney General of the United States. I think that the people on this committee are all better than that, and I would encourage us to be focused on this important issue moving forward for the duration of today's hearing. Thank you, and I yield back.
The gentleman yields back. For what purposes does Mr. Gates seek recognition?
I move to strike the last word.
Gentleman is recognized.
I know my colleague who just spoke is new to the committee, and his comments about distraction certainly remind me of moments that we endured in 2017. We had legislation before the committee, good legislation, bipartisan legislation, to stop the Larry Nassars of the world, to not allow them to move from one job to another and harm people. And we debated that bill for like 3 hours. And you might ask, well, what was the substantive dispute? It was that the Democrats were like, you know what, Larry Nassar was a real bad guy, and we should protect Olympians. And you know who attends the Olympics? Russia. And then they spent hours and hours pursuing the Russia hoax. Now, I look forward to improving and supporting this underlying legislation, and we will have amendments to ripen some issues that I think can really help our American workforce. But we must address a searing matter before the Judiciary Committee and before the country. To label parents domestic terrorists for showing up at school board meetings and caring about their kids is abhorrent, unpatriotic, and un-American. But to lie about doing so is even worse. And somebody knew. As the Attorney General was testifying before this committee saying he couldn't imagine ever appending a label to a parent of domestic terrorism, someone was watching at the FBI and they understood that that was dishonest. that did not paint a clear picture of what was actually happening, because there were threat labels that were being put on folks who loved their kids and who showed up. So here's my question. How many? How many Americans right now that went to a school board meeting, that emailed a parent, that confronted a principal, that reached out to their school board members, that ran into a superintendent at the supermarket and expressed their view? How many of those Americans right now are carrying a threat label with them? What's next? Can't fly on airplanes? Can't access the U.S. financial system? Get doxxed at their job? Get deplatformed online? The Department of Justice has been politicized, weaponized, and turned against our fellow Americans. But when the Attorney General came and visited us, it was an interesting moment on the calendar, because we were days away from an election in Virginia and New Jersey. And maybe the Attorney General believed that because that election was around the corner, he could downplay the aggressive, unpatriotic action that he had taken against America's parents by telling us something different. You know, when Americans lie to the Department of Justice, they get prosecuted, especially when they're conservatives. But when the Attorney General seemingly lies before our committee, the majority doesn't even have follow-up questions. And by the way, this is the same Democratic majority that indicted Steve Bannon because he wouldn't show up while attempting to resolve whether or not there was an executive privilege issue. But then when people actually show up and mislead and are dishonest, there is far less contempt displayed in the face of that dishonesty. My fellow Americans, if the Department of Justice will send the Attorney General here to lie to us, to mislead us, then they will lie to you. I was at dinner recently in Florida with my wife, and a clean-cut dude in his 30s comes up, taps me on the shoulder, and said he was a member of federal law enforcement. And I asked what entity, and he said that he wouldn't tell me, but it was the one I criticized the most. And he said, Mr. Gates, you need to understand that the same divisions that exist in our society today also exist in the FBI. And we're not all up for these terrible things that we see in our organization. And he said, tell Mr. Jordan thank you for the great work we do, and to know that there are great patriots out there that are working hard to protect our fellow Americans. I'm glad there was a real whistleblower that stood up to tell us what was really going on, because otherwise we wouldn't know. Well, I wonder who that is.
You know, just keep talking. They're not really turning you off. Yeah. It is a little bit like a Twitter moment, though, isn't it? Mr. Chairman, I would ask that the gentleman have an additional 1 minute under the circumstances.
Mr. Chairman, I'll yield my remaining 30 seconds.
The gentleman will suspend. We don't have a clock yet.
Oh, my.
That's a reason to keep going. Is that foreign interference?
Go ahead, man. My time didn't run out. There's no clock.
And then we have the lights.
Among the unprecedented events of this Congress.
Have you ever seen that? I've never seen that.
Mr. Chairman, can Mr. Gates have a redo, second act?
You had me at hello, Mr. Cohen. If we don't get the Attorney General back, maybe you can bring the chicken.
I want to remind all members that masks must be worn unless you're recognized to speak.
Does that only count if the counter's on and the lights are on?
No.
Well done.
Let's be in, no. Is this the intermittent power we've been promised in natural resources?
I understand this is a building-wide issue. The committee will stand in recess.
Audio check, 1, 2, 3. So audio is there.
Lectern.
This is an audio check from 2141, audio check 1, 2. So you're in the booth, can you check with, can you check with Media Center?
Yeah, 1 second.
All right,
And this is me off of Zoom, Eric. You got me? 1, 2, 3.
Yep, hear you loud and clear. He's
Okay.
about to check with Media Center now. Yeah, we're not.
All right, copy that.
We're not seeing video.
Just not seeing program in the output of my codec yet.
It's This is an audio check from 2141, audio check 1, 2, 3, 4. James, if you're still on there, could you speak as well so we can verify far end to Media Center?
Okay, here's the platform to the hearing room. 1, 2, 3, 4, 5.
You get that, Aaron? All right, thank you.
The committee will come to order. At the point we recessed, Mr. Gates was speaking on the amendment in the nature of a substitute. I recognize him for his remaining 1 minute.
Thank you, Mr. Chairman. I said all I needed to, and I'll yield back.
The gentleman yields back. Who else seeks recognition? For what purpose does Mr. Raskin seek recognition?
I move to strike the last word, Mr. Chairman.
The gentleman is recognized.
Thank you. First, thanks to my distinguished colleague, David Cicilline, and Ms. Jayapal, and especially to Sherry Bustos, who I know has been working on this for several years. In medieval Europe, kings and feudal lords enjoyed the droit du seigneur, the so-called lord's right, the right of a king or feudal superior to have sex with any subordinate woman in the kingdom. In modern corporate America today, we have bosses who think they have the right to have sex with any woman who is a subordinate employee and the right to sexually harass, grope, and assault any woman below them on the organizational chart. This is false. Sexual harassment is illegal sex discrimination under federal law and state law. Sexual assault is a crime in the states. Corporations are not sovereign royal kingdoms in America, but chartered entities subordinate to the democratic state and subject to the democratic rule of law. So what's the disconnect? Why is there an epidemic of sexual harassment in our country? Well, yesterday we heard from 4 brave citizens about modern corporate lords and kings who act as if they are above the law and enjoy the droit du seigneur, all because of the regime of forced, closed, and secret arbitration that has been imposed on tens of millions of American women by corporations that have effectively set up their own private systems of justice. We're about to change the toxic work environment for our daughters, our mothers, our sisters, our friends, the environment that plunged the lives of Eliza Dushko, Laura Henry, Andoua Newton, and Tatiana Spotswood into hell. This may be the most important thing that the Judiciary Committee does in the current Congress, and this will be the most important labor law change of the new century so far. The whole purpose of the original Arbitration Act was to allow 2 big businesses to settle their private contract disputes voluntarily on the assumption that they operated on a plane of equal bargaining power. But a sequence of terrible Supreme Court decisions kept expanding the domain of corporate arbitration over employees and consumers until the very narrow and discrete exception of voluntary corporate arbitration for 2 businesses swallowed the rule that every American citizen has a right under the 7th Amendment to a jury trial when facing a civil wrong or injury. We should observe that our legislation strikes a major blow, not just for America's workers and America's women, but also for federalism in the states. The corporate arbitration takeover through the Federal Arbitration Act is a massive violation and usurpation of the rights of states, state law, and state courts to hear cases involving violations of the rights of women under state anti-discrimination law.
Would the gentleman yield?
Yes, by all means.
Doesn't the law, the bill before us, prohibit states from allowing these claims, so arbitration agreements for these claims to be enforceable?
No, it does not. On the contrary, what it does is to say that women will not be forced under the Federal Arbitration Act into a closed, secret arbitration over and against federal and state law. So, but yeah, I'm not quite sure what you're referring to. I mean, under this law, any woman who wants to enter freely and voluntarily into an arbitration agreement post-violation of the law may do so.
Would the gentleman yield again?
Yes, by all means.
I was talking about a pre-dispute arbitration agreement. This law, you talked about your concern for federalism.
Yes, indeed.
But this, as I understand it, this bill will prohibit any state from making pre-dispute arbitration agreements on this subject matter arbitrable, enforceable.
No. What it does is to say that a woman has a right against any provision that would obligate her to participate in a closed arbitration, exempting her from being able to bring an action in federal or state court. So we're restoring women's rights to sue under both Title VII at the federal level and under any state law that's adopted or passed. So, yeah, I mean, I think that's a misapprehension of what the law is. Remember, this is the Federal Arbitration Act that essentially is occupying the field and displacing federal and state law and people's rights under the 7th Amendment to go to court to sue. So, look, the 7th Amendment is in the Bill of Rights, just like the First Amendment, just like the Second and Third and Fourth and Fifth and Sixth and so on. The 7th Amendment says that we shall preserve the right to jury trial, and that's what we're going to do with this legislation, and we're going to score a major victory for the women of America and for civil justice in our country. I yield back, Mr. Chairman.
Gentleman yields back. For what purpose does Mr. Biggs seek recognition?
Move strike the last word.
Gentleman is recognized.
Thank you. It's my understanding that the purpose of this bill in the ANS is actually to provide a choice of forum for the victim of sexual harassment and sexual assault. That's my understanding. And I think that is a worthy and noble cause. I think the language on page 2 of the ANS, starting line 19 and extending to line 8 on page 3 are problematic. I hope that those will be revisited and fixed because I do think that there's a chance that some will actually use the language that's there to try to redefine sexual harassment in a way that's different than has been well established through the case law that's been developed in this area over the last 40 years. So I hope that gets taken care of. But in the meantime, I'm going to, and by the way, I'll suggest that if it does get taken care of, then I will be for the bill, and I think Mr. Buck's amendment is the right answer to that. So, so let me just real quick cover a couple things. And one of which is dealing with Merrick Garland. And I think it is critical that we discuss this because I do think it is a critical issue as well. And I look back and I think what happened on September 29th, and there was a letter that went to Mr. Garland, the Attorney General. And within a few days, on October 4th, he issued a directive to the FBI and other departmental components to proceed forward to investigate parents who showed up at school board meetings. And what he said was there's a disturbing spike in these types of incidents of harassment, intimidation, threats of violence. Now, when asked about that, Mr. Garland said, well, I haven't seen any data or reports. He says that he'd seen a newspaper account or something like that. That's what he relied on. And then later, he testified on the 21st that parents would never be considered domestic terrorists. He said, oh my goodness, we would never invoke the Patriot Act on them. And a whistleblower has come forth that the day before that took place said that indeed the Criminal Investigative Division and Counterterrorism Division of the FBI was pressing forward and putting a tag on parents who showed up. They tasked their counterterrorism unit to sit by in Americans. Parents who happen to exercise their rights to speak at school board meetings. Parents who want to make sure their kids' education is appropriate. That's a Soviet-style surveillance. So I'm left saying, well, either he didn't know what was going on, in which case that ought to give us real major pause for concern, or he did know and he lied and perjured himself on both points with regard to designating parents as terrorists and use or misuse and abuse of the Patriot Act. On both of those. So you got reports from whistleblowers that, and we actually have a copy of the memo. We have a copy of the memo that was issued. So this is something that's really serious, and we should have a hearing and bring Merrick Garland in here to answer these serious questions. And with that, I'll yield some time to the gentleman from Ohio, Mr. Jordan.
Well, I'm just going to make the point, and I appreciate the gentleman yielding in his comments. Earlier, Mr. Gates gave a speech before the place went black. He gave his remarks, and he asked, I think, the appropriate question, what's the number? What's the number of Americans who's now have a threat tag on their name? How many moms across this country now have a terrorist tag associated with their name? And guess what? Only one person can give us that answer, the Attorney General of the United States. So the question that Mr. Biggs just raised, Mr. Chairman, is the most important question we have to deal with today. When will you call the Attorney General back and set him right there at that table so we can ask him those questions? That's the question. That's you. Mr. Biggs raised the right question. I yield back to the gentleman from Arizona.
Thank you, and I'll yield my final time to the gentleman from North Carolina, Mr. Bishop.
I don't think we can do anything to touch the surface here. I would suggest to you that on page 3 of the bill, there is a prohibition of arbitration, pre-dispute arbitration, for any claim federal, state, or tribal in this bill. That's not concern for federalism, but we'll come back and talk about it later, I hope.
The gentleman yields back. We have 2 votes on the House floor. Therefore, we will recess and return immediately after the conclusion of those votes. The committee stands in recess. committee will come to order. I remind everyone that the attending physician has said that for the public health of everyone, people should wear a mask except at all times in a building except while speaking. I now recognize the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, yesterday we witnessed the real-life consequences that sexual harassment and sexual assault in the workplace can cause, that being fear, anxiety, hopelessness, and frustration that all too often leads to broken lives and irreparable harm. The victimization of employees is compounded and aggravated by the use of forced arbitration, which shuts down the ability of an aggrieved employee to hold their employer responsible for sexual harassment and assault in a court of law. Forced arbitration was created as a for-profit business by business for business, and it has worked quite well for business for many years, especially for those businesses that choose to retaliate rather than reform, those that seek to silence the abused and promote the abuser. Forced arbitration allows businesses like these to put their reputations first and their employees' safety and security last. Because unlike the civil justice system, which is developed through centuries of statutes and case law, the arbitration process is not required to be based on the rule of law. It fails to provide even the most basic procedural guarantees of fairness and due process under the law that are hallmarks of our legal system. The fact of the matter is that in most forced arbitration cases, the corporation is entitled to choose the arbitrator, the procedures that apply, and the location where the arbitration will take place, which could be far away from where the employee lives. There's no public accountability because most arbitration proceedings and rulings are secret. Discovery is limited, and rules of evidence almost non-existent. The corporation gets to choose the time, the place, and the procedure, and controls the selection of the arbitrator. So it's no wonder that the corporation usually wins the case and the employee is left with no recourse. Put simply, the deck is stacked in favor of Goliath to the detriment of David. As evidenced by the compelling and heartbreaking testimony we heard yesterday, forced arbitration makes it more likely, not less, that corporate harms and abuses will go unchallenged, unnoticed, and too often swept under the rug so that the culture of sexual harassment in the workplace never changes, and the wreckage of broken lives continues to accumulate. I support this bill. I support it for my wife, my daughter, my staff, my colleagues, and for every single person who has been unjustly silenced by forced arbitration. This bill will return power to the victims and survivors. It will empower them to share their stories and bring them into the light. While this legislation will not end sexual harassment in the workplace, it will level the playing field so that employees have a fair shot at being able to hold corporate wrongdoers accountable. And my sincere hope is that this bill will lead to nationwide change in workplace culture. I commend my colleagues, especially Sherry Bustos, Pramila Jayapal, and David Cicilline for introducing this important legislation. I urge my colleagues to support this bill. And if any of my colleagues on the line need my remaining 1 minute, I will yield to them. But hearing no response, I will yield the balance of my time. Thank you, Mr. Chairman.
The gentleman yields back. For what purpose does Mr. Shabbat seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman's recognized.
Thank you, Mr. Chairman. Yesterday, we heard moving and deeply troubling testimony from witnesses who had been victims of sexual assault. The actions described in detail by the witnesses, which occurred during the course of their employment, It was really sickening, and in my opinion, each of the attackers ought to be in jail right now. I think, as is, the underlying legislation is well-intentioned, but it could be improved, in my opinion, by addressing issues raised by the witnesses, by Mr. Ice, and by others on this committee. I hope that before this bill gets to the floor for consideration, we will address the concerns that they raised. Shifting topics, Mr. Chairman, this has already been raised by a number of my colleagues on this side. Last month, Merrick Garland, the Attorney General of the United States, sat in front of this committee and testified about circulating his now infamous memo, which instructed the DOJ and the FBI to work with local law enforcement to target concerned parents at school board meetings. The memo was issued only 5 days after the National School Board Association urged the Biden administration to target parents using the tools provided under the Patriot Act. At that hearing, I provided an example of a specific incident that was cited by the National School Board Association, which they apparently believed rose to the level of domestic terrorism. And then specifically asked the Attorney General if that was the type of act that he contemplated investigating as domestic terrorism. Now, his response was that he, quote, can't imagine any circumstance in which the Patriot Act would be used in the circumstances of parents complaining about their children, nor could he imagine any circumstance where they would be labeled as domestic terrorists. Now, that's what he said. Well, Mr. Chairman, Republicans on this committee have sent letter after letter to the Department of Justice, to the National School Board Association, and to you in an attempt to get to the bottom of this. Turns out the Attorney General wasn't entirely forthcoming in his answer to my question. In fact, we now know, thanks to the efforts of a whistleblower, that the day before his appearance in front of this committee, the FBI had circulated a memo directing agents to monitor parents at school board meetings and to flag all, all potential, in their view, criminal threats, harassment, and intimidation of educators with an edu-officials threat tag. This is clear and compelling evidence that the use of counterterrorism measures against parents had, in fact, been authorized before the Attorney General's sworn testimony. In light of this troubling new information, Mr. Chairman, I urge you to call the Attorney General back before this committee to testify about the FBI's threat tag directive and his statement before this committee, which now appears to have been less than fully accurate. And I yield back.
The gentleman yields back. For what purpose does Mr. Correa seek recognition? Gentleman is recognized.
First of all, let me thank my colleagues for this most important legislation, Ms. Bustos, Ms. Jayapal, and of course, Mr. Cicilline. And I want to thank also the victims for stepping up, having the courage to tell their painful stories in front of us, in front of the public. In my prior life, I authored a lot of legislation against sex crimes. Sex crimes are very painful subject. And most victims do not speak out about their traumatic experience. Most victims stay silent and bear the pain in silence. And by staying silent, these sexual predators continue to perpetrate their crimes. So I thank you, the victims, for speaking out, the courage for speaking out, and putting these individuals out of business. Yet, I can't help but think that many other victims that speak out are then silenced by secret settlements. Secret settlements preclude those victims from speaking out and for us from knowing the full extent of the crime. Secret settlements shield these sexual predators from all of us. How can we know the extent of a crime, of an issue, unless victims speak out? Mr. Chairman, I will be supporting this legislation today, but I hope that this committee comes back and addresses the issue of secret settlements, especially in the area of sex crimes. And with that, Mr. Chairman, I yield.
The gentleman yields back. For what purpose does Mr. Tiffany seek recognition?
Move to strike the last word.
Gentleman is recognized.
We heard moving testimony yesterday. There's no doubt about it. But I got to tell you, about 8 o'clock last night, I was stunned, simply stunned, that I, my neighbors, my friends, constituents, could be viewed as a threat to this country just because we're going to school board meetings, that we would get a threat tag put on us. I've attended, as I spoke in my remarks and questioning of Attorney General Garland, about how I've attended numerous school board meetings along with friends, constituents, and others over the last year and a half. And to hear yesterday that they may have a threat tag put on them is unbelievable. And Mr. Chairman, we ask today that you work with the ranking member and this side to bring the Attorney General back into this room, and let's be able to question him, because he clearly was not forthright with the memo that went out October 20th, a joint message from Criminal Investigative Division and Counterterrorism Division. And if that isn't strong enough, when we had that hearing, there was talk of using the Patriot Act. There's a portrait right over there in that corner of a man who used to serve as the chair of this committee. He wrote an article a few weeks ago saying the Patriot Act, which he helped write, one of the primary authors, Mr. Sensenbrenner, the Patriot Act was never meant to go after citizens of this country. Yet that appears to be what is happening. So I'll take you back to the questioning that I did of the Attorney General almost 4 weeks ago. I asked him, are we terrorists? No, you're not terrorists. Are we criminals? And he dismissed that. He said, I'm sure you're not. He basically dismissed it. But I've followed up with a third question, and I went back last night and studied his answer. I asked, have any states asked for help? And his answer was, we're doing an assessment. So in other words, is that assessment? Is it administering threat tags? Was it sleight of hand so that we did not get to hear what happened on October 20th, that it was not going to be forthcoming, that these threat tags were being put out all over the country by the FBI? The Attorney General needs to come back here, and he needs to answer that question, because I will pose it to him. If you look at number 3 in this joint message on counterterrorism, the third question here says, what's the motivation behind the criminal activity? Sounds like they're already guilty. Sounds like it's already guilty. And that's certainly what it seems like the National School Boards was attempting to do when they went and brought this forward and said, Biden administration, you need to sic your Attorney General after these parents all over America who the light has come on and they understand we have to get involved in our kids' schools. You might want to bring in Director Wray, too, after you get done with Attorney General Garland. So a couple of my colleagues were speaking earlier. One of them referred to, in regards to the issue before the committee today, said the deck is stacked and it's David versus Goliath. He's absolutely right. In this context also, threat tags being put on parents, the crushing weight of the federal government is coming down on parents with these threat tags. The Attorney General, the FBI, they're coming after the parents. It was also cited by another member, corporations put themselves above the law. Well, what about when our government puts themselves above its citizens? It's not a good thing, is it? He also called it a distraction, what we were attempting to do today. Distracting from parents being harassed. The Judiciary Committee needs to do its job, Mr. Chairman. We will work with you to bring the Attorney General back here to have another round of questioning, and then I hope you follow that up by bringing FBI Director Wray after that. And let's see if their stories mesh. Bring the Attorney General back before us. I yield back.
The gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
To strike the last word, Mr. Chairman.
Gentlelady's recognized.
Mr. Chairman, we're at a pivotal moment in history, again in this committee, as we've often been. A life-changing approach to women and men and others who have been sexually harassed and managed to be brutalized twice with no remedy. Forced arbitration, in the context of today's markup, should be immediately stopped. And I'm delighted to join and be a co-sponsor and to congratulate Congresswoman Jayapal, Bustos, and Cicilline, and others who have worked to bring this horror to an end. It's a horror because it is an example of the privatization of the justice system. And let me be very clear. It is a circumstance where we hope people will have a choice in which system they desire. But what my friends on the other side of the aisle fail to realize is that there is no choice, because those employees sign agreements, many of whom, or much of what, is not read. And as I heard a witness say, they're so excited about the new job that it is in fact not accounted for. And so let me read, if I might, or summarize testimony from yesterday. That's why this is a significant day to bring justice. Using arbitration as an alternate system of justice is entirely unfair to the victim because arbitration lacks the transparency and presidential guidance of the justice system. This is forced arbitration. Forced arbitration is not an alternative regime for resolving claims. It is a means of suppressing legal claims altogether. It is frightening. It is demeaning. Forced arbitration takes power away from the everyday individual, but it takes the option of the court away as well. So, one of our witnesses said her employee showed up at her house, displayed his penis, his real penis, injected it, getting prepared for abusive sex. One of our witnesses had to stand in front of an entire cast of the show Bull, an outstanding actress, actor, producer, and to be publicly humiliated and sexually harassed. One of our witnesses was noticed and stalked by a hugely rich man at the ages of 13 and 14, all the way to the point where she thought that was behind her, and she was so excited about taking a job under this multimillionaire's leadership, and wound up being physically and savagely raped in a foreign country to escape only with her life. Fearful that she would not get on a plane, she kept to herself until she could get out of the country. And then what about a young lady who suffers from PTSD and had an employer put his body parts on her head as she sat by her desk? She's still employed and lives in fear every day. Professor Gillis of the Cardozo Law School said, "It is long past time for Congress to enact legislation that limits the reach of these pernicious clauses. The Supreme Court has expanded the reach of the Federal Arbitration Act, wrongly so." And so I know my colleagues are enthralled with actions of the Attorney General, who they have not yet documented. But I am overwhelmed by the senseless abuse of women in the workplace. So much so, Mr. Chairman, I'm asking to put into the record an article depicting the actions of these private companies. The company that sells Love to America had a dark secret for thousands of women working at the nation's largest jewelry retailer meant unequal pay and harassment at worst. One of the employees said a manager said to her he wanted to lick her head to toe. Ask unanimous consent to place in the record.
Without objection.
I ask unanimous consent to place in the record the teeny tiny fine print that can allow sexual harassment claims go unheard, and that was a forced arbitration.
Without objection.
It is important today to do the work that is before us. If there's any such proof that any parent has been harassed, I'll stand with you. But we are here now to stop harassment of millions of women that have gone unattended to, and we should be about that business and take it seriously. Mr. Chairman, I yield back.
The gentlelady yields back. For what purpose does Ms. Fishbach seek recognition?
Mr. Chair, I move to strike the last word.
Gentlelady's recognized.
Thank you, Mr. Chairman. First, I do want to say what has happened to so many women in the workplace is terrible. And I appreciate the women who testified yesterday and the strength that took. And I appreciate their appearance before our committee. But this bill really does attempt to accomplish a goal that current law already accomplishes. In our hearing yesterday on the bill, the comment was made over and over that the point of the bill is to shed light on the harassment that women have suffered. But arbitration clauses are not preventing victims from going public.
Would the gentlelady yield? Would the gentlelady yield?
Let me just finish. Thank you so much. But the arbitration clauses are not preventing victims from going public. If the goal truly is to shed light on sexual harassment or sexual assault, then victims can simply ignore the arbitration clause and sue anyway, which I know that some of them have. There are better ways to shed light on sexual harassment than the government interfering in private contracts. Make no mistake, this bill is also looking to open the door for federal involvement in employment contracts. We have seen bill after bill from the other side of the aisle that wants to increase federal regulation and involvement in the economy and every other aspect of life. Now we have another one. This bill is one of over a dozen bills that want to insert government into private agreements. It's not being considered in a vacuum. There's a concerted, ongoing effort to involve the federal government in these private contracts. This bill assumes that it is the government's job to decide for people what is in their best interests. But America has succeeded for centuries because the government has stayed out of people's lives. I know Minnesotans don't want Congress telling them how to run their lives, and they don't want Congress to be dictating terms of private contracts. My constituents want less government in their business, not more. My constituents are already upset about the influx of spending bills, which seem to intentionally aim to make life in America more difficult by increasing taxes and inflation, bureaucratic regulation, and government involvement in their lives. I have concerns in many ways with this bill in which it is written, and it would push more and more claims into the court, which we, as we heard yesterday, are already overwhelmed. Hopefully, there will be some good amendments today to address some of these concerns. I urge my colleagues to protect the rights of Americans to decide contracts for themselves. Thank you, Mr. Chair. And there was someone.
Would you yield now? Would you yield now?
Yes, and I'm sorry, I'm online, can't tell who's asking, but I will yield.
Thank you. I was struck by your comments. The purpose of this bill is not to shed light on the harassment, nor is it to increase government's interference in contracts. The purpose of this bill is to enable choice, to enable women who are sexually abused to choose whether they would whether they would prefer to have their accusations determined by a private arbitration proceeding or by a federal court. It is to give them that choice. Under current law, unfortunately, they often do not have that choice. They have signed away when they agreed to take the job in a clause which they didn't even know was there probably, and it's non-negotiable. You know, and you sign a 17 or 20-page employment contract, and buried in there is a mandatory arbitration clause that says you have no right, should a dispute arise or should you be sexually harassed, you have no right to go to federal court. You must submit it to private arbitration. This which has fewer discovery rules, which 98.1% of the women lose in arbitration.
Reclaiming my time, Mr. Chair, because I'm running short and I did want to address that. I wanted to say, Mr. Chair, with all due respect, over and over yesterday when we were taking testimony, we heard that this was in order to shed light on these claims and to make sure that they were public. And so there was a lot of that. So like I said, with all due respect, the testimony yesterday did say that it was about shedding light on these claims. And so I just wanted to, I appreciate your comments, but that's not what the testifiers told us yesterday. So with that, Mr. Chair, I yield back.
The gentlelady yields back. For what purpose does Ms. Dean seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
First, I'll apologize for my hoarse throat. I hope you can hear me. I want to associate myself with the remarks of my colleagues, Mr. Jones and Ms. Jackson-Lee, as to the proper, respectful, important focus of this markup. I can't imagine what the four women of strength who testified yesterday must be thinking when they hear some of the comments coming from the other side. And second, I wanted to make note of something maybe you made note of. We had to stop this markup. We had to stop our work because of darkness. We cannot properly work in darkness. We cannot properly strive for justice in darkness. It felt like a metaphor for the very thing that we are talking about now, which is forced arbitration. So I rise in support of ending forced arbitration in Sexual Assault and Sexual Harassment Act. This bipartisan bill would end the use of forced arbitration for sexual harassment disputes. And as I said at yesterday's hearing on the bill, words matter. We are discussing forced arbitration, not voluntary arbitration, not arbitration at large. We're talking about forced arbitration. Can't you hear it in the words themselves? Under the very basic language of this bill, any claim related to sexual harassment won't be forced into arbitration. It's simple enough. Should a victim wish to handle her claim in arbitration, it is his or her right and his or her decision. That's the way it should be. The bill would simply not force this legal agreement onto victims, agreements that are buried in contracts, as you have so ably noted, Mr. Chairman. In the United States, the 7th Amendment guarantees us a right to trial by jury of our peers, but forced arbitration puts this right in jeopardy, puts this right in darkness, puts this right out of reach. Unlike the judicial system in which courts' decisions are generally public, by building on precedent, cumulatively creating a body of law, the results of arbitration disputes are often kept secret. Coercion, siloed conversations, you can hear the very problem in the name forced arbitration. It is the difference between light and darkness. Through forced arbitration, a company has the power and may increase the expense of bringing a claim, limit discovery or access to counsel, and the right to bring similar claims jointly. Additionally, the company imposing arbitration often selects the arbitrator, him or herself. Relying on the concept of arbitrators self-reporting is silly at best. This bill is written to empower survivors to speak out with hope, protect additional victims from known perpetrators. It does not define sexual harassment for any purpose other than what type of case can escape forced arbitration. As Ruth Bader Ginsburg wrote in her dissent in Lamps Plus versus Varela in 2018, quote, "How treacherously we have strayed from the principle that arbitration is a matter of consent, not coercion," end quote. I encourage all of my colleagues to lend their support, and I yield the remainder of my time.
The gentlelady yields back. For what purpose does Mr. FitzGerald seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, reserve a point of order.
Point of order is reserved. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 4445, offered by Mr. FitzGerald of Wisconsin. Page 4, line 6. Strike the closed quotation marks and the period at the
Without
end.
objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I have a friendly amendment at the desk. The testimony that we heard yesterday was just gut-wrenching and unacceptable, obviously, in the workplace and in any setting. But I believe there is something that we should consider as a committee, and I think it makes a lot of sense. Sexual assault is a violent crime, as we know, and victims of sexual harassment in the workplace should not be silenced. However, the bill as written advances the interests of the plaintiff's bar by making it much less likely arbitration will be used for disputes, including some that may have little connection to the underlying sexual assault or harassment. Typically, class action lawsuits require turning over a large share of any recovery to the lawyer for less. So, I mean, if we are going to focus on the victim, and if we are going to make sure that the wherewithal is there for them to heal and to get the types of services and counseling that they need, I think this amendment does a lot towards working towards that goal. This amendment prioritizes monetary relief to the plaintiff employee over fees for the attorneys by requiring final determination of, quote, any monetary relief to be paid to the plaintiff and payment to the plaintiff before, unquote, before payments of the cost of the attorney's fees. So it's not a complex or difficult, obviously, item to grasp. It's a concern. I mean, if you have somebody that goes out and seeks counsel and then later on finds that, they signed a contract that said anything that was recouped, well, half of it's going to go to the attorneys. Well, that's not right. That's terrible. It further requires that the amount of the recoverable attorney fees not exceed a reasonable percentage of a victim's direct recovery, and that at no event can the lawyer receive more money than the employee, which we have heard has happened. This provision addresses the reality that attorneys are often incentivized to oppose efficient and fair resolution of employee claims, and even to advise against arbitration, because more efficient and less costly resolution of claims usually results in lower legal fees. This is something, obviously, that it has not been part of the discussion that we had for the most part yesterday, and for today, I don't remember talking about this, which is why I think there's a uniqueness to obviously addressing this in the bill. This incentive unfortunately exists even when protracted litigation delivers no further benefit to the employee. And that's why I think, like I said, I think this is a friendly amendment. I think this is something that makes a lot of sense. This is a very unique and difficult and tedious legalese that exists, and as a result of that, I think that the amendment makes sense, because this will ensure that victims of sexual assault and sexual harassment receive justice in the end, and the ability and the resources they need to recover. And I would yield back.
The gentleman yields back. Does the gentlelady insist on a point of order?
I do, Mr. Chairman. I believe this is outside the scope.
The gentlelady is correct. Clause 7 of House Rule 16 prohibits amendments that are on a subject matter different than the proposal under consideration. The subject of the bill we are currently considering is the prohibition of arbitration in sexual assault or sexual harassment disputes. The gentleman's amendment proposes to put conditions on attorney's fees related to civil litigation, not to arbitration, which is a subject different from what we are considering in this bill. The amendment, therefore, is not germane and violates Clause 7 of Rule 16. For what purpose does Mr. Buck seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to HR 4445, offered by Mr. Buck of Colorado, page 2, line 21.
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, this amendment is straightforward. What it does is it changes the definition of sexual harassment in the bill, particularly page 2, starting in line 19, subsection 4. It defines sexual harassment as harassment of a sexual nature as defined by applicable federal, tribal, or state law. I offer this amendment having talked to my colleagues on the other side, Mr. Chairman, as well as others, because I think this amendment is essential to clarify the fact that the definition that is in this legislation for sexual harassment is not the definition that should be used by a court to determine whether a sexual harassment has actually occurred. I understand that it is the intent of the sponsors of this legislation that this definition is to be used to determine whether a plaintiff is entitled to choose between arbitration and between a court action. I want to make sure that by striking this language, we clarify and make certain that the federal, state, and tribal law is the law that governs the determination of whether, in fact, a sexual harassment has occurred or not, given the facts of the case. I think right now it is ambiguous, and while I understand the motive and rationale for the language that is currently contained in the bill, I think this bill would be stronger by just relying on federal, state, and tribal law. I can tell my colleagues that I believe there is support in the Senate, in spite of the fact that this bill has passed as we currently see it, the Senate Judiciary Committee by voice vote. I believe there is support in the Senate to revise this language and have the language that is contained in my amendment ultimately in this bill. I intend to vote for this bill regardless of whether my amendment is adopted or not in this committee. But I do intend to very strongly suggest to the sponsors and others that we clarify this. I don't think their intent is to change sexual harassment law given this statute. I think the intent is, as the chairman said earlier, the intent is to give a plaintiff the opportunity to choose the forum for their action. I think this is confusing and strengthens the bill. And with that, I yield back. Or no, Mr. Cicilline, do you want to be ready?
I just wondered if you would just yield for a quick
I yield to Mr. Cicilline.
So I thank the gentleman, and we've had an extensive discussion about this issue along with Congresswoman Jayapal and Congresswoman Bustos. And what I want to say is I think that what you're concerned about is clearly not the intention of the bill. This bill does not seek to expand the definition of a sexual harassment beyond what exists in state and federal law. I think it does not do that. This is simply kind of a funneling mechanism. But I understand what you have raised, and I think what we can commit to do is include report language that makes it clear this doesn't expand any of those definitions. It is simply to determine whether or not it is forced into forced arbitration or not. And the same requirements will be required in whatever court they present their case to meet whatever is the appropriate state or federal law with respect to that offense. I think we can make report language that makes it clear it doesn't expand anything. I know we are working very closely with our Senate partners to be sure that they are in sync with any revision. And so what I would commit to you, I know Ms. Jayapal will, as well as Ms. Bustos, is let us work with our Senate partners to figure out whether the colloquy that I just provided, as well as some report language and maybe some modest, tinkering will reassure you, because it is not the intention of the sponsor to expand the definition in any way. I don't think the current bill does that, but before we make any changes, We want to be sure that our Senate partners are in alignment as they've already passed it in its current form. But between now and the time it gets to the floor, we commit to working with you in good faith to achieve that clarification that you seek.
I reclaim my time, and I thank the gentleman for clarifying that. I also want to just mention that I very much appreciate Greta Carlson being here today and recognize her hard work on both sides of the aisle in moving this legislation forward. And I also appreciate Representative Bustos and her great efforts in this bill. And I thank the gentleman for his comments, and I yield back.
Does the gentleman withdraw the amendment?
I am not withdrawing the amendment.
For what purpose does Ms. Jayapal seek recognition?
Mr. Chairman,
Does she insist, first of all, do you insist on your point of order?
I withdraw my point of order.
Point of order is withdrawn.
And I do wish to speak on this amendment.
Gentlelady is recognized.
Thank you, Mr. Chairman. I want to thank the gentleman from Colorado for his sponsorship of the bill and for his thoughtful comments. I do concur with Mr. Cicilline that I do not think that this bill defines sexual harassment for any purposes other than what type of case can escape forced arbitration in an initial gateway determination of what's carved out of the Federal Arbitration Act. We'll work with you, Mr. Buck, to see what we can do in the report language, just to make it clear. The current definition in the bill is already far narrower than most every other definition of sexual harassment, and this bill reflects the significant input of our colleagues in the Senate, including Senators Graham, Grassley, and Blackburn. So I do thank you. I do rise in opposition to the amendment.
Would the gentlelady yield?
I do.
For a question, Ms. Jayapal, over here. So the first thing that you just said is that this definition of sexual harassment in the bill is narrower than in many places in law. Could you give an example of that?
Let me get that for you. I don't have it right here in front of me, but let me get it for you. I think that I'm happy to get that and get back to you.
So, and that troubles me. I can't imagine, to the point that I made earlier in this hearing, I think you and I had a colloquy over it. My concern is that and I went through in some detail how much the United States Supreme Court has made a very clear standard, legal standard for what constitutes actionable sexual harassment, and it has an objective part and a subjective part and so forth. Which is really important. And I gave I contrasted the provision here that refers to unwanted sexual attention, which is not even limited to, but includes unwanted sexual comments and propositions for sexual activity. But I don't know what else that might be. So here, my concern is, what the purpose of having? Can you articulate what is the purpose for having? You say this is for defining the types of claims that are not, that are exempted from enforceability of arbitration.
That's right.
And so my question would be, what is the need to define something for that purpose that is broader than harassment of a sexual nature as defined by applicable federal, tribal, or state law? In other words, if it is a cognizable claim under federal, tribal, or state law, that's the only law in the United States of any kind, then why do you need to have something broader to exempt from arbitration?
Well, this is, go ahead. No, go ahead.
No, if the gentlelady would yield.
Yeah.
Again, I think what the gentlelady has explained is this is a determination as to whether or not the matter is protected from forced arbitration.
That's what I just said.
If, in fact, the matter is to be litigated in a court, wherever that court is, the relevant jurisdiction would have the standard that must be met by the plaintiff in that action. That remains unchanged. And so it doesn't enlarge, it doesn't make it, you can't go into the court and say, oh, I can't meet my burden of proof, but forced arbitration was precluded, so I've met my burden of proof. No, the plaintiff would still be required to meet whatever elements are required under the statute in the relevant jurisdiction. That remains unchanged. Right. But to the extent there's any anxiety about that, I think the sponsors of the bill have expressed a willingness to clarify that it is not the intention that there be any enlargement, but this bill is passed in its current view, both with Republican and Democratic support in the Senate. We don't want to agree to an amendment that may compromise it being enacted into law. And so all we're saying is this colloquy is now part of the official record. We've committed to working with you in good faith, both in report language and potentially an amendment to the underlying bill. Right. And I think that's there's not much left to do other than to agree to an amendment that our Senate colleagues have not agreed to do, which could be the fate, could be the end of this bill. We're not willing to.
Just one thing is, just reclaiming my time for a minute, just one thing I wanted to make sure is we are talking about current pleading standards that apply in every state and federal court in the country. And so when we're making it very clear that every allegation made when filing a lawsuit has to be supported by facts and evidence. And again, I would just bring this back to, this is a bill that passed unanimously out of the Senate Judiciary Committee. And so we don't want to tinker with the language, and we understand Congressman Buck's concerns, and we will make sure to address it in the report language or with our Senate colleagues if there's a way to fix it in a way that's satisfactory to you. Thank you. I yield back.
The gentlelady yields back. For what purpose does Mr. Gates seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you. And I know that oftentimes the amendatory process on legislation in the Judiciary Committee can seem pedantic, but we come in peace. You know, Mr. Buck and I want to see this bill become law, and we would like to see it become law with the broadest possible support. And to achieve that support, we simply offer our drafting suggestions so that the bill doesn't do something that the proponents of the bill don't intend it to do. And what I believe Mr. Cicilline said is that there's not an intent to expand the definition of what constitutes sexual harassment. Again, not to be pedantic, but would the gentleman also agree that, or I'm sorry, would the gentlelady agree that it's also not to alter the definition of sexual harassment, either as an expansion or a contraction? I would yield to the gentlelady. Terrific. So one suggestion, if the specific language of the Buck Amendment is troubling, maybe as we continue to consult with our Senate partners and move this legislation through the Rules Committee with the report language, we might think about some comfort language that would just state that plainly, that nothing in this act would be intended to alter the definition of sexual harassment as has developed in federal, state, and tribal law. I would yield to the gentlelady.
Thank you. I think we've already said we're willing to work to try to figure out how to make you more comfortable with this. We do appreciate that you both have been supportive of the legislation, and we would like you both to be on the bill, obviously, and vote for it. And so let us just continue to work through that. This is carefully negotiated language, so we'll work with you as we go forward.
Great, and again, that would just be a tool in the suggestion box for all of us to work with the Senate partners, maybe that type of language that would say, you know, notwithstanding clause. And I would also just note that, you know, substantively, there's a reason why the jurisprudence on sexual harassment has developed in a way to lash the persistence of harassment with the unwanted nature of that harassment, because the persistence gives notice to someone engaging in behavior that it is in fact unwanted. And the language here that's included in the bill seems to lack the requisite notice that would make this type of behavior actionable. And so we want to make sure that we're not altering that in any way. I think the report language just should be specific, that we don't want to alter the definition, but that we do believe that the forum to resolve these questions is not the private sector system that the powerful develop so that they get to choose their juries in advance. And you have these powerful entities who frequently interact with arbitration panels, and a person who is alleging that they've been harassed or abused is only going to interact with that arbitration panel, one time maybe in their entire existence. And that's what I find so unfair about the entire system. And so I appreciate the thoughtfulness of my colleagues. Again, a notwithstanding clause or like the Buck language we have before us to append to that report language. And I would hope before the report language is finalized, since we're engaging in these discussions now, that you might be willing to chat with some of us over here in the minority that simply come to try to ensure the greatest possibility for passage of the bill. And I yield back.
The gentleman yields back. For what purpose does Mr. Bishop seek recognition?
To strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. So let me pursue this a bit further. And Mr. Buck has said that he offers the amendment. The amendment is not determinative as to whether he'll support the bill. It is determinative as well whether I will support the bill, unless I can, and I'm trying to discern whether there's some articulable reason for creating a new definition for sexual harassment here. That was the purpose of my questions, which I appreciate Ms. Jayapal entertaining on her time.
Would the gentleman yield?
Well, just let me get started.
for a second.
No, sir, not right now, but I'll try to get to you in time. A couple things here. The first thing I want to understand from Mr. Buck, can you say publicly, you just said a voice vote in the Senate has adopted this amendment or something like that?
No, what I was saying was that the Senate Judiciary Committee adopted this legislation by voice vote.
Okay, all right. So
When the statement was made earlier that it was unanimous, it was a voice vote.
Well, and just, is there, other than, Mr. Cicilline, your concerns about the fact that the bills will match as they are proceeding in their terms, and this would be a change in some way that might make, I guess, final passage less likely at some level. Is there any other substantive reason for defining, for this new definition of sexual assault or sexual harassment? And
Yeah,
I'd yield if the gentleman cares to respond.
Yeah, of course. I thank the gentleman for yielding. Well, it's two things. One is, in fact, this language was carefully negotiated with Republicans and Democrats in the Senate and passed, though by voice vote, it counts the same unanimously of the Judiciary Committee.
I understood,
Okay.
and I made the proviso.
I said there's two
Is there a
reasons. So-
substantive reason?
Yes,
If you'd address the substantive reason, it'd be great.
No, I understand, but actually ensuring that it gets enacted into law, I consider a substantive. Like, we want to make sure it actually becomes law. The second thing is, with all due respect to my good friend, Mr. Buck, this amendment actually is problematic because, at the very least, you would have to include allegation of harassment of sexual nature as defined by applicable, not just, you wouldn't have to prove the allegation before. So this is why it's hard to draft and make changes on the fly like this. And I don't know how much more sincerely I can communicate that we understand your issue. We're committed to solving it. This is too important an issue to vote against. Vote for the bill with a strong commitment on the record. We will solve this problem in a manager's amendment before it comes to the floor, so long as we can consult with our Republican and Democrat colleagues in the Senate and not impede its ultimate passage. That's the only point.
So thank you.
I thank you for yielding.
I thank the gentleman for that effort. And I will say that I don't think this is that hard. So, for example, the point that you just made about, or the gentleman from Rhode Island made about, said it should say involving allegations of or something. Mr. Buck, actually, it's a very artfully drafted amendment. All it does is takes the term, this is where it fits in the sentence. The term sexual harassment dispute means a dispute relating to. That's the language under the original bill and under Mr. Buck's amendment. Mr. Buck's amendment picks up right there and says relating to harassment of a sexual nature as defined by applicable federal, tribal, or state law. That's all his says. Now, it doesn't say allegations of, true, but neither does the original bill. It says relating to, actually it says relating to the any of the following conduct, but it's already got a typo in it, the any of the following conduct directed at an individual or group of individuals, and then lists off these things like unwelcome sexual advances. So the bill, that's not the problem, that it doesn't involve a language or doesn't include language concerning allegations of. This is, the definition of sexual assault that's included here with 5 separate subparagraphs is so elaborate that to say it's been carefully worked over, but no one be able to, as we sit here today, to explain what the purpose is of the 5 subparagraph definition when you could just say it in about 10 words.
Would the gentleman just yield
Buck
for a second?
Well, let me just finish the sentence, then I will. I don't understand there's got to be some rational reason, or in the lack of one, I can't support the bill at this time, but I will yield to Ms. Jayapal.
Thank you. I just wanted to again clarify that if you're talking about page 3, section 4, A, B, C, D, E, when you say the 5 things, that is not a definition of sexual harassment. That is sexual harassment dispute, which is just about the dispute that then goes forward, and then it is still left to the state courts.
Same question applies, Ms. Jayapal, which is why define all of that at great length? In other words, why do you need to have a much more elaborate language for that purpose?
Because it's a very specific carve-out. Because we are trying to narrow these so that they are very specific.
They can't be broader than the claims under law. And I yield back.
But they aren't. Thank you. I yield back.
Mr. Chairman? The gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady is recognized.
Let me say that what I have heard from my colleagues on the other side of the aisle is how potent the testimony was of the witnesses yesterday. I would share with you that there are eons of women who are not in this room who are today facing the same kind of groping, harassment, fear, intimidation, loss of jobs, single mothers with 4 children at home depending on them, a young lawyer who I think of all the witnesses was still employed by the company that is abusing her. Now, Mr. Buck has had, as many of us have, long years in different phases of the practice of law. And let me see if I can characterize what troubles me about the language of the amendment before me. The arbitration is before a court decision. Arbitration is before discovery. And so when you indicate federal, tribal, or state law, you replace what is an exceptionally narrow definition with a standard that is tied to the different heavy burdens of state, federal, tribal law at the very beginning. And you raise the bar and the burden of the victim at the very beginning of his or her case. In the instance of our witnesses of her case. This bill is only about whether or not the victim can choose, the person can choose to go forward and to choose whether she wants to be engaged in arbitration without being forced. It's about what the victim will plead. It is about what a victim must plead at the onset of the case in order to move beyond a defendant's motion to compel forced arbitration.
Would the gentlelady yield? Ms.
Yes,
Lee?
sir.
So, I think that's precisely my concern. If, let's say, you have a claim for race discrimination, which this bill does not, by the way, exempt from arbitration agreements on its face. And so, at the very end, you put in something that says, and I had a manager leer at me one day. Does that then get that race claim exempted from arbitration? It's one example. I probably come up with another. Let's say you have a contract claim wherein someone is paid $300,000 wage. No, she has a commission entitlement, and so she adds that line at the end of her description of her claim. She's not contending that she has a claim under Title VII for sexual harassment or anything of the like, but she puts that in there. Does she then get the benefit of this exemption? That's what I'm trying to ask about. Are you trying to make a broader category of claims exemptable from arbitration under this language?
Reclaiming my time.
And ones that would be...
Congressman, reclaiming my time, it is to insist that you do not put a heavy burden on the already traumatized victim by insisting what level of law she complies with, or he, the victim of abuse or sexual harassment, and to allow them to do, I think, one thing, if I'm listening to the proponents of this legislation, to have a choice. If you force upon her the standard or the burden of meeting the framework of law, you have burdened her on the very simple question, what is she choosing? Is she allowed to get out of the forced arbitration, or must she now be forced into forced arbitration? It's a simple question. It's a simple category of law. It's not unpainful, and it's not unviolent, and it's not unabusive, using quotes around the un. It is, and it's separately at a very particularly emotional time. And I think this language adds an extra burden to the victim, and particularly it imposes an exceptionally high standard on victims, which is normally used for purposes of proving liability. Asking the victim to try and meet the standard when a case is filed means no victim will ever be able to move forward. So I want to finish my remarks. At this time, as I read the bill, I think the point was to relieve the victim of her burden. And with that, Mr. Chairman, I respectfully oppose the amendment, but respect the author of the amendment. I yield back.
Gentlelady yields back. For our purposes, Mr. Shabbat seek recognition.
Move to strike last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I yield the gentleman from Colorado.
I thank the gentleman from Ohio for yielding, and I don't want to beat a dead horse here. I don't know if that offends anybody.
Too late for that.
But I do think what we say on the record is important to frame the discussion that we will have after this with our Senate colleagues and how to do this. And I also think it's important to note for the record that many of my Republican colleagues have come up to me and to Mr. Gates and said that they would support this bill with the amendment. I understand that we don't want to change the bill as it stands now, but I also don't want anybody to think that a vote against this bill after we have finished amending it or not amending it is a reflection of the support on this side of the aisle for this bill or for the cause that the bill stands for, and that is giving justice to those who have been victims of rape and harassment. And I think it's important to debate this issue so that that is thoroughly recognized and understood. As to Mr. Cicilline's point about using the word allegation, the reason I framed this amendment the way I did, I took the same language that was used for sexual assault dispute, the definition of sexual assault dispute. The term sexual assault dispute means a dispute involving a non-consensual sexual act, ... This language is the term sexual harassment dispute means a dispute relating to, and then I put this language in. I think the word dispute addresses the concern about whether the term allegation is in there or not. Happy to change both to allegation or leave the word dispute in both, but I want to make sure that I am not trying to hide the fact that we have a dispute or an allegation. I'm not saying that someone has the prima facie burden of showing the case before discovery in this situation. So I thought the word dispute covered that. Happy to work with my colleague on that issue and the sponsor of the bill on that issue. But I yield, or I would ask the gentleman from Ohio to yield to the gentleman from North Carolina if he would.
I'd be happy to yield to the gentleman from North Carolina.
And I will do what Mr. Buck said he was not going to do, just to clarify where we are on this. I've, as Mr. Gates whispered in my ear, he knows I've spent time in a state legislature. I've been promised that something will be fixed after I voted for it before, and I generally don't see the need for that, although I understand the majority will pass it. But let me just say, and Tim, the gentleman from Rhode Island's offered to sort of try to create some legislative history that might try to ameliorate the problem that I anticipate here. First of all, legislative history is not what it once was in the jurisprudence of the United States. But Ms. Jackson-Lee's comments are just as much a part of the legislative history now as Mr. Cicilline's, and it's very much the point. If one has entered into an arbitration agreement and one suffers suffers an injury in the nature of sexual harassment, gives rise to a claim, then according to what is contemplated here, that person wants to go to court. If they want to go to court, then they file a lawsuit and they plead a claim. And then if someone says, well, this claim is arbitrable under the agreement, the judge looks at the language of the arbitration agreement, looks at the claim, looks at this new modification of the law and says it is or it is not a claim that is exempt from the arbitration agreement. And that requires pleading a claim for sexual harassment under state, federal, or tribal law. So unless there's an intention to do something more than that, in fact, if Ms. Jackson-Lee's saying you want to now relieve the person of their obligation to plead a claim under sexual harassment law and yet some other way get out of an arbitration agreement, that's precisely the problem. And it's why I can't vote for the bill in current form, but I would if it were fixed. And let's see, that's Mr. Shavett's time. I yield back.
Reclaim my time and yield back.
The gentleman yields back. If no one else seeks recognition, the question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no?
No.
The opinion of the chair, the noes have it.
I'd like a roll call vote, please.
Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee?
Hey there, where?
Ms. Jackson Lee votes no. Mr. Cohen?
No.
Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass?
Bass votes no.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell?
Show, brandish, any way whatsoever.
I've got a vote.
Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Nagus? Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No. Dean votes no.
Ms. Dean votes no. Ms. Escobar? Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa?
Yes.
Mr. Isa votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. McClintock? Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey?
Massey votes aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
Mr. Chairman, how am I recorded?
Ms. Lofgren, you are not recorded.
Lofgren votes no.
Mr. Chairman, how am I recorded?
Ms. Escobar, you are not recorded.
Escobar is a no.
Mr. Nagus?
Nagus votes no.
Mr. Nagus votes no.
Mr. Chairman, how am I recorded? Hank Johnson?
Mr. Johnson, you are not recorded.
No.
Mr. Johnson.
Mr. Chair, how am I recorded?
Mr. Liu, you are not recorded.
No.
Mr. Liu votes no.
Is any other member who wishes to vote not voted yet? Clerk will report.
Mr. Chairman, there are 15 ayes and 20 noes.
The amendment is not agreed to. For what purpose does Mr. Benz seek recognition?
Strike the last word, Mr. Chair.
Gentleman is recognized.
Thank you, Mr. Chair. I just want to call out for purposes of clarification that a couple of things that it appears the bill does and the bill does not do. It does apply to all agreements to arbitrate, notwithstanding the language in the short title which suggests that it's only forced arbitration. I just want to draw people's attention to page 2, line 1, which reads, any agreement to arbitrate or dispute. The reason I raise this issue, Mr. Chair, is because, of course, this bill, if passed, will apply to all existing arbitration agreements. Of course, it's been suggested it's not retroactive because it would only apply to disputes arising hereafter, but that, of course, means it would apply to existing contracts, millions of them, as has been noted. I secondly want to call out that, for purposes of clarification, that this bill applies to arbitration. And the reason I call this out is because there are many means of alternative dispute resolution, such as conciliation, mediation, neutral evaluation, settlement conferences, and community dispute resolution programs. I want it clear this bill does not apply to any of those.
Would the gentleman yield?
Yes, I will.
Yeah, if you look at page 3 of the bill, beginning, everything before that is definitions. It says, notwithstanding any other provision of this title, at the election of the person alleging conduct constituting a sexual harassment dispute or sexual assault dispute, etc. So this limits the bill to sexual assaults. It is not a bill applying generally to pre-dispute arbitration agreements, only to pre-dispute sexual assault allegation arbitration agreements. Now, the fact is, I wish it covered everything. We had a bill, we reported that bill called the FAIR Act, but that hasn't passed the Senate. This is a much narrower bill, and as you can see from the language starting on line 10 of page 3, it applies only to pre-dispute arbitration agreements regarding alleged sexual assaults.
Thank you, Mr. Chair, for your clarification, and that was indeed what I was attempting to accomplish, which is that these other means of alternative dispute resolution are not affected by this bill. I also want to call out that the assumption underlying the bill is that everyone would be better off by going, or at least having the opportunity to go to court. And what I would suggest is going to happen is that in the future, as contracts are put together, what we will see is, of course, those who are going to be on what we will call the defendant's side of the ledger will say to themselves, why should we put arbitration in, giving those who might be challenging us in court a choice? They won't. What will happen is you won't see arbitration anymore, and instead, those of us who work so hard to put together alternative dispute measures that would reduce the cost to plaintiffs so they could actually have their day before a tribunal will not have it. And so I call this out because it seems odd that we would assume, as this bill does, that everyone's going to be the better for having the choice. Well, assuming that there will be a choice is a bad assumption, because what will happen is you'll simply go back to the day that the contract is being negotiated, and you'll see that those on the side of power, if you will, those who are to be affected by this bill probably directly, are going to say, wait a minute, why are we going to give an advantage to someone when we can simply take that alternative, that choice away from them? And I'm guessing, Mr. Chair, that folks gave this a great deal of thought, and they're willing to take the chance that the future choices available to those who have been harmed are going to be limited to court, and they have decided that that's fine, because that's going to be the result of this bill. And with that, Mr. Chair, I yield back.
The gentleman yields back. For what purpose does Mr. Roy seek recognition?
Strike the last word.
Gentleman is recognized.
Well, first of all, I'm sorry we've been bouncing around, obviously going on the floor and having lighting issues. I do want to say a couple things. One, with respect to the underlying bill, I will admit to being torn on where I end up on the bill based on a lot of the comments that would be reflected in my colleague from North Carolina and some of my other colleagues here. I'm disappointed in the result of the amendment vote that was offered, which I think might have moved some over on this side of the aisle. But I do hope to have a continued dialogue about this. I have enormous concerns about the power that is accreted in corporations on multiple levels. And we had a good conversation earlier this summer on antitrust. This is obviously an issue that raises serious concerns with respect to the power of corporations and how that...
Did the gentleman yield?
Briefly, yes, sir.
Yeah, I agree with you. The purpose of the bill is precisely to limit the power of giant corporations, which now, by putting in mandatory arbitration agreements, force the little guy to take the arbitration instead of the court. The purpose of the bill and the effect of the bill, at least with respect to sexual assault allegations, as I said, we haven't passed the bill more generally, which I'd like to do.
Am I reclaim my time unless you'll give me an extra 30 seconds? Will you give me an extra 30 seconds?
Sure.
Extra minute? Okay.
The purpose of the bill is precisely to give the individual the choice of whether he or she would prefer arbitration or going to court, and not permit the giant company to compel him or her to go to arbitration.
Well, and I appreciate the additional time, whatever that may be, another hopefully minute. Mr. Chairman, I would say, that was a minute question. I would say that's precisely why I'm torn, right? Because I understand the purpose of that, and I share that goal, okay? And I've shared that goal, frankly, even in the larger bill of a couple of weeks ago. My problem with that one was I thought it was overly broad. There were a number of issues with it. I can't remember them all off the top of my head at the moment. But there are a number of issues with this. The definition that we've already debated and offered amendment on is one of those. My only point of raising that is that at the current moment, I'm a pretty strong lean no. But I hope we can have a continued conversation about this going forward and offer amendments as we continue to debate this issue on this particular area, but then there'll be others I suspect that my colleagues on the other side will bring forward as well. I do want to bring up, just because I'll have limited time and we may have to go vote in a minute, I don't know if I can come back, the troubling revelation today, not just what's already been discussed by my colleagues with respect to the Attorney General generally, but a targeting now of South Lake High School Independent School District in Texas with respect to civil rights. I think it's through the Department of Education and not the Department of Justice, but it is a troubling connection that it can't be coincidental that there's a now targeting of a school district in Texas, which has been one of the lead school districts in Texas pushing back on critical race theory. And indeed, there's been many flipped seats with respect to school boards in that state. And I'm troubled because of what we have already discussed here in this hearing with what the Attorney General's lack of response. I sent a letter on October 6th asking for him to reject and rescind this investigation targeting parents. We now have this email. I would hope that my colleagues on the other side of the aisle would be equally troubled and want to investigate this, but even go further. I mean, in my questioning with Attorney General Garland, and as we sit here and talk about the problems with sexual harassment, which are very real and pervasive and concerning, I raised my concerns with the Attorney General, which I will not repeat or dwell upon, but obviously the horrific sexual assault that occurred in the Loudoun County Public School, which I attended. I attended a Loudoun County Public High School, that we had that occur in May, and then we had a follow-up in October in a sister high school, all of which could have been avoided if we hadn't been politicizing what has been occurring in school boards and allowed simply a father who is disgruntled and angered about what had occurred to his daughter to address a school board. And now you've got the Attorney General of the United States and the Department of Justice and FBI targeting parents. I mean, we have it here. They're targeting parents. And you've got an email from the head of the counterterrorism division. I mean, and then you've got the Attorney General responding to me in inquiries. He says, no, I do not think that parents getting angry at school boards for whatever reason constitutes domestic terrorism. It's not even a close question.
then why is the head of counterterrorism division out here putting out information targeting parents? And then now we see South Lake High School being targeted, South Lake, I should say school district, independent school district being targeted, and with some troubling focus on that school that I don't think is coincidental. So I hope that this committee will dive into this and ask the Attorney General to come forward and explain what's going on. And I would hope, and I appreciate the extra time from the chairman, I would hope that we could have a continued dialogue on this legislation and future legislation on arbitration. I think you've seen there's an appetite on this side of the aisle to try to address these concerns.
Mr. Chairman, I have a unanimous consent request.
The gentleman yields back his time. For what purpose does Mr. Cicilline seek recognition?
Mr. Chairman, I have a unanimous consent request. I ask unanimous consent that a letter from Terry Poor, the Policy Director at Ralliance, be introduced into the record. Unanimous consent.
Without objection?
A unanimous consent request that a letter from survivors of sexual harassment and assault silenced by forced arbitration be admitted into the record.
Without objection?
Copy of an op-ed by Eliza Dushku, published in the Boston Globe, detailing her experience with harassment and forced arbitration, be entered into the record.
Without objection?
And a letter from Jennifer C. Braceras, the Director of the Independent Women's Law Center, be entered into the record.
Without objection?
I yield back. Thank you, Mr. Chairman.
For what purpose does Mr. McClintock seek recognition?
To speak to the bill.
To strike the last word?
Well, to speak to the bill, we're under a 5-minute.
Gentleman is
rule.
recognized.
In fact, just on a parliamentary point, this business of striking the last word, that's in effect an amendment. That's not necessary when we're debating a measure of the 5-minute rule.
Well,
If the Judiciary Committee can get rid of that silly sophistry, I think it would be making a significant contribution to the parliamentary process in this House. Now to the question at hand. You know, we established yesterday that there is no arbitration agreement that can in any way impede criminal charges being brought against a sexual predator. Nothing in any agreement can impede that process in any way. And we also established that provisions in the contract of adhesion where there is an imbalance of power between the two parties cannot be enforced under current law. My concern is what this bill does is to impede the freedom of an employee and an employer to negotiate the terms of employment that are mutually beneficial to both parties. No one is ever forced to agree to terms of a contract that they find unacceptable. That requires a gun, and guns in the conduct of commerce are a really bad idea. There is an absolute defense that anyone has against a forced agreement. It is the word no. In any contract, there are provisions that one party may like and the other party may not like. Again, that is the purpose of a contract. Each party weighs the provisions they like and the provisions they don't like and decides if the sum total of those provisions justify entering into the contract. If an employer won't negotiate an arbitration agreement provision, it's obviously very important to that employer. If an employee doesn't object to such a provision, it obviously isn't very important to them, at least at the time. Other benefits in the agreement obviously outweigh their concern about an arbitration provision. In my judgment, this should be left to the judgment of the parties involved, not to parties like us that are butting our noses into an agreement between two parties that have the natural right to come to a mutually agreeable contract with each other. The conduct described by the witnesses yesterday is despicable, and we have very good criminal laws to punish such actions. This is not at issue. At issue is solely the process to resolve a civil dispute over what a plaintiff is owed by a defendant. There are various ways to resolve that dispute, and agreeing in advance to the process of resolving these disputes is perfectly reasonable. You know, it's said that, well, this simply gives the plaintiff the choice of arbitration or trial. But here's the problem with that. If it's done before a dispute arises, both parties are on an equal footing, neither can see the future, and the principles that they're agreeing to apply equally to both. After a dispute arises, one party can benefit at the expense of the other. To me, that just seems unjust. I do also want to join my colleagues in strongly requesting that the Attorney General return before this committee and explain the glaring discrepancies between his testimony on the targeting of parents protesting before school boards and what we now know about the actions of his department. We entrust the Justice Department with the most terrifying powers that our government possesses. The power to seize property, wreck careers and reputations, deprive people of their liberty. In short, we give them the power to destroy people's lives. I think it is imperative that these powers be rigorously regulated and vigilantly overseen. That is one of the primary purposes of this committee, and wholly accountable to the people. These powers should be used only to uphold the Constitution and protect the liberties of the people. Its authority is not merely force. It is also a moral authority, and when it's used politically or corruptly or unjustly or unevenly, I think it loses that moral authority, and therefore it loses its legitimacy and ultimately the allegiance of the people. We need to have a very serious and sober discussion with the Attorney General about all of these things. And Mr. Chairman, with all due respect, ignoring it is not going to make this issue go away. Ignoring it is going to cause that issue to fester and grow until it's resolved. With that, I yield back.
The gentleman yields back, and I, despite Mr. McClintoff's objections, I recognize myself to strike the last word, and I recognize myself for 5 minutes. The Supreme Court has acknowledged that all consumer and employment contracts are contracts of adhesion, but most contracts of adhesion are also enforceable. Each survivor who testified yesterday was subject to contracts that deprived them of rights in the face of rape, sexual assault, and sexual harassment. In every case, they were in situations in which they had no bargaining power. None of them could escape their adhesive forced arbitration clauses. As Ms. Newton testified, although she attempted to negotiate her contract, her employer quickly made it clear that no aspect, including the forced arbitration agreement they attached, was negotiable. The opportunity of a lifetime was a take it or leave it offer, and LVMH made sure to remind me, I'm quoting her, of the hundreds of other candidates ready to take the position if I declined. The truth is that contracts of adhesion are still enforceable. In most cases, these contracts do not rise to the level of unconscionability required by courts to render them unenforceable. The standard for unconscionability is very high and requires an element of procedural and substantive unconscionability. And as we saw with all our witnesses yesterday, they were subject to adhesive contracts. Take it or leave it. They were told, if you want this job, if you want this opportunity, if you want to continue working as an actress, you must sign an agreement giving away your rights to go to court and agreeing to forced arbitration. So this is not that's why the bill is still necessary. I yield back. Who seeks recognition?
I have an amendment at the desk, Mr. Chairman. Are you going to break for votes or go into that?
What vote? Oh. The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
They're on the west side.
Amendment to the
where they
amendment
are.
in the nature of a substitute
have
to
a
HR
relationship.
4445, offered by Mr. Bishop of North Carolina. Strike.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
I thank the chairman. And I'm glad Mr. Raskin has returned to the committee room because this amendment is inspired by what he said earlier today about the bill before us respecting federalism, meaning the power of the states as individual sovereigns within the greater union. And as I said at the time, and he disputed this, perhaps we'll have a colloquy during the course of this if I have enough time to clarify. It's important to understand where the law is and what this bill would change it to do. So the Federal Arbitration Act since 1925 has provided that any arbitration provision in any contract, quote, evidencing a transaction involving commerce, close quote, shall be valid, irrevocable, and enforceable. And all the cases that have developed over time have carried out the implications of that. It makes arbitration agreements enforceable to the extent of the Congress's interstate commerce power. That's what Section 2 of Title IX does right now. And it's a very simple bill, or it's a very simple statute. The pro-federalism approach here, if you wish to do what this does, for a long series of decisions, probably can't be explained in the context of where we are, sexual harassment claims do arise out of the employment contract. And therefore they evidence that it's involved in a contract evidencing interstate commerce. And so the federal government has occupied the field and said all those arbitration agreements are enforceable. What the federal government should do, the Congress should do now, is to exempt from that sexual harassment claims. It should, and that's very simple. This bill, but what is in the bill right now, before I go explain my amendment, what is in the bill right now is this provision, Section 402, no validity or enforceability. And if you get past the intro language, it says, no pre-dispute arbitration agreement or pre-dispute joint action waiver shall be valid or enforceable with respect to a case which is filed under federal, tribal, or state law and relates to the sexual assault dispute or sexual harassment dispute. So it doesn't respect federalism. It doesn't turn it back to the states to decide whether those claims should be arbitrable or not within the confines of each of those individual states. It flips what is already a federal preemption across the land on its head and says the states can't decide. It prohibits them from deciding. New York's already passed such a law, but there's at least a trial court decision saying, that is to say, New York has said, under New York state arbitration law, sexual harassment claims not arbitrable. They're not going to enforce an arbitration agreement. But the court has said, no, the Federal Arbitration Act preempts that law. So my amendment would be far simpler than what is proposed here. It would respect federalism, as Mr. Raskin said was his objective, or what he believes is the appropriate objective of the bill. And it simply says the existing Federal Arbitration Act, Section 2 of this title, shall not apply to claims related to sexual assault disputes and sexual harassment disputes. So with that, Mr. Chairman, I will see if anybody wants me to yield the time, but absent that, I will yield back.
Gentleman yields back. I will recognize myself.
But I withdraw the point of order. It is germane.
Point of order is withdrawn, and I recognize myself in opposition to the amendment. The amendment seems to repeal the whole bill. It repeals the whole bill and removes the choice from the victim. So,
well, Mr. Chairman,
there's not much else to say about the amendment. It repeals the whole bill.
Mr. Chairman, you yield.
Sure.
It doesn't repeal the bill. It does certainly have an effect. It says the Federal Arbitration Act is no longer going to render these agreements enforceable in cases of sexual harassment disputes. If you live in New York and you have a contract under New York law, as of the day this takes effect, there will not be any, you cannot have enforceability of an arbitration agreement because that state's law prohibits it. It simply takes the federal disrespect for federalism that Mr. Raskin talked about earlier, and it is a partial repeal of the Federal Arbitration Act insofar as it made arbitrable sexual harassment disputes.
Yeah.
I yield back to the gentleman.
The amendment repeals, in effect, Section 402, subsection A, which defines what the bill applies to, and leaves the bill applying to nothing. And then it says the title, Section 2 of this title, which is the effective title, which is the effective action part of the bill, shall not apply to claims related to sexual assault disputes and sexual harassment disputes. I was going to say it guts the bill, but it doesn't gut the bill. It doesn't gut it. It eliminates it. So on that grounds, I oppose it. I yield back.
Mr. Chairman. Mr. Chairman.
There are votes on the floor, so the committee will stand in recess and will reconvene as soon as the votes are over. The committee will come to order. For what purpose does Mr. Roy seek recognition?
Move to strike the last word.
Gentleman is recognized.
With all due respect to Mr. McClintock. Before we left a little while ago, I just wanted to make clear what I think my friend from North Carolina is saying and why I think it ought to be of interest and debate for the committee. And to clarify, because the chairman said something which I don't believe is an accurate description of what my friend from North Carolina's amendment does. I believe that what the amendment did, and I'll yield to him to clarify if I don't get this right, but is to make an exception specifically to Section 2 of the Federal Arbitration Act. And in that, as he's drafted it, right, Section 2 of this title shall not apply to claims related to sexual assault disputes and sexual harassment disputes. And in doing so, would say that, okay, whereas we are now in a place where this federal arbitration regime over years of application of law applies in this context, well, let's take it out of that context. And to the gentleman from Maryland's point about federalism earlier, take that and put it back into the purview of the states, and then we'd be able to go from there, in terms of actually effectuating that goal. And I think that is a good faith attempt to sort of unwind some of our concerns about the breadth of the FAA, the Federal Arbitration Act, in this context, and provide ability for some flexibility of states to then be able to structure this in ways that they think is appropriate for the circumstances of businesses and peoples that are, in their states. Would the gentleman from North Carolina like to clarify?
I think the gentleman from Texas, I think that's right. And I don't want to repeat it. I'm anxious to hear what Professor Raskin will have to say, because he was interested in the federalism, and I think he's happened upon the right idea. Chairman Nadler said that the amendment took away the full force of the bill. It certainly does not. If the reason we're here, according to the proponents of the bill, is that the Federal Arbitration Act forces people to arbitrate under their agreements, even if it's a sexual harassment claim. And so the bill's fix for that is to say, nowhere in the United States, not under federal law or under any state's law, you cannot have arbitration of a sexual harassment claim. In other words, it uses preemption. Right now, it uses preemption to force the arbitration agreement. Under the bill, it would use preemption to prohibit any arbitration of sexual harassment. But state legislatures are perfectly capable of deciding this. New York already has. I happened to come across that in looking up something yesterday. I'll bet you California has. And so all this, so my amendment, instead of having the preemption effect and using Congress to make, frankly, the same error that was made from the perspective of Mr. Raskin, I think appropriately in 1925, to sweep up these claims within the federal enforceability of arbitration agreements, it partially repeals it. It repeals the Federal Arbitration Act insofar as it would require enforceability, or it would make arbitration agreements enforceable as to sexual harassment claims. That's a great way to do it. It's a lot much preferable to the way the bill does it now. I thank the gentleman for yielding the time.
Yeah, and taking my time back, I would just say that I think, there are areas, as I alluded to before, with respect to our conversation on antitrust in July, that really short hearing that we had, and this issue where I think there is a desire to reach, bipartisan accord on this subject. And I think this is a good faith attempt by my friend from North Carolina to attempt to do so. And with that, I will yield back, Mr. Chairman.
The gentleman yields back. For what purpose does the gentleman from Maryland seek recognition?
I move to strike the last word, Mr. Chairman.
The gentleman is recognized.
Thank you very much. I just wanted to respond to the gentleman from North Carolina and Texas. And I appreciate the gentleman listening at least to half of what I was saying in my support for the legislation. The first half, of course, was that the current co-optation of people's Seventh Amendment right to jury trial has created this regime of sexual harassment and sexual assault in workplaces throughout the country. And this has not only resulted in the kinds of events that we saw so vividly yesterday in the testimony of the 4 brave women who came before us to talk about what it meant to be forced into a coerced, closed, secret arbitration system, but also to have to endure that kind of haughtiness and impunity by male aggressors in the workplace. Then I went on to add, and this was by way of refutation of those who were saying that this was somehow an assault on federalism, that the current regime is an assault on federalism because states like New York, which want to say you can't force women into corporate arbitration, are unable to do so because it's preempted by federal law. So if we've had 75, 90 years, 50 years, 30 years of trying it in one direction, and I think you've endured that with some equanimity, then I would say that let's try it the other way. Let's go back to the 7th Amendment jury trial and not force women into coerced arbitration, whether it's by the power of a particular lobby in Washington or a power of a particular lobby in the state capitals. Let's go ahead and do it. Yes, by all means.
I thank the gentleman. I just wanted to ask, your point in your initial comments that sort of inspired this amendment on my part was that the bill shows respect for federalism. So in other words, you talked about, and you've just recapitulated that in a way to say, the problem with the FAA, the Federal Arbitration Act, from your view, in your view, at least insofar as we're dealing with here today, is that it imposes this federal rule everywhere.
Well, that's not actually, I mean, that's reclaiming my time just for a second. Just to be clear, that's not my essential critique of it. Right. My critique of it is that it cheats women out of their 7th Amendment jury trial right.
Sure, I get that. And you could say that without ever having said anything about federalism.
But I needed to respond to those people who are riding the horse of federalism today when, as I think you would have to concede, nobody was raising federalism over the decades in which women were being forced to endure this regime and states could do nothing about it.
And would you agree with, sir, that to the extent the Federal Arbitration Act does not respect federalism, this bill does not respect federalism to exactly the same degree?
Well,
because it uses
I don't think that's right, because I think there's a lot more pressure at the state level to protect women's rights than there is to protect the rights of large corporations.
Totally agree. So it'd be great to leave it to the states to do it like New York has done.
Well, let's come back in 50 or 70 years, and then the scales will be even, and then we can check it out. See, I happen to think it's interesting to me that the good gentleman from North Carolina had the idea for this based on what I said rather than from the beginning. In other words, the initial resistance to this legislation is all about saying, well, maybe there's something really good about forced arbitration. Maybe that's freedom of contract, and that should trump the jury trial right. And then the insight came later when I was responding to, I think, a couple other members who were asserting that there was a federalism interest. To me, it just feels like the kitchen sink. The bottom line question is whether women are going to have to endure a regime of sexual harassment and assault because the bosses who are doing it feel like they can operate with impunity under a secret and closed regime of forced arbitration.
Bottom line, I think the gentleman was originally correct. It'd be great to respect federalism and fix the problem at the same time. I yield. Thank you.
All right. Well, if I still have any time left, Mr. Chairman, I would just say this is a really big deal, what we're about to do here. This is a major advance in terms of the quality of work life for tens of millions of people across the country, tens of millions of women of every conceivable racial, ethnic, geographic, partisan, political viewpoint. This is about emancipating women to just get back to the level of what the founders were talking about, having a jury trial right to enforce their civil rights in court and before a jury. Not a right to win, but just to get before a jury and to have due process. So I'm very excited that we're moving forward on this. I do think it's going to allow the state laws as well as the federal law of anti-discrimination to come back into force across the country. And I yield back to you.
The gentleman yields back. For what purpose does Ms. Sparks seek recognition?
To strike the last word.
Gentlelady is recognized.
We have a lot of legal scholar debate here, and I understand that's important. But we also the major concern, I think, it still wasn't fixed in this bill. The breadth of the definition allows, and I think, I was very upset that the other side didn't take Mr. Buck's amendment to really clarify that the redefinition will be followed from the state laws if they are federal laws. And if we leave open this bill how it is with all of this ambiguity, it opens up a can of worms, which potentially, I'm sure a lot of trial lawyers might like it, but it can destroy businesses, especially small businesses, and we need to pay attention. This doesn't apply to large evil corporations. It does apply to any business, and there are a lot of these businesses already struggling, and we're going to put more potential, burden on them. So I think it's very disturbing to me. So I hope maybe at some point this bill will tighten this definition, because this definition is broad and could be, and I'm not an attorney, I'm just a normal person, but when I read it, and I'm not trying to imply that attorneys are not, but you guys like ambiguous stuff. Attorneys love ambiguous stuff. It keeps you in business. But when I read it, it's just very ambiguous, and that's very concerning. So I hope, this, committee and authors of this bill are going to look how to fix some of this and clarify that, and I'll be open-minded to support, because maybe there is a real challenges that we need to deal, make sure that they're, also done in the court of law better than maybe with arbitration, and that's not for me to judge, but I think the definitions have to be clear and clean, and what Congressman Bucks, suggested, that was one of the alternatives. What now Congressman Bishop is just suggesting is there a different alternative to states to really deal with that issue. Don't have federal government superseding the state decisions. That's another way. So maybe you guys support this one, but there needs to be to tighten this legislation, and I would appreciate if you would support these solutions, and I yield back.
The gentlelady yields back. Does anyone else seek recognition? If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it.
Request a roll call vote.
Roll call is requested. The clerk will call the roll.
Just kind of to start off.
Mr. Nadler?
No.
Released.
Mr. Nadler votes no. Ms.
Up until
Lofgren?
Wednesday, they were
No.
released on Saturday.
Ms. Lofgren votes no. Ms. Jackson-Lee?
No.
Ms. Jackson-Lee votes no. Mr. Cohen?
Mr. Cohen votes no.
Mr. Cohen votes no.
Unmuted.
Mr. Johnson of Georgia?
Johnson of Georgia votes no.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No. Bass votes no.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Stimmings?
No.
Ms. Stimmings votes no. Mr. Correa?
No.
From our first meeting was.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones?
No.
Mr. Jones votes no. Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa?
Yes.
Mr. Isa votes yes. Mr. Buck? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe? Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey?
Massey votes aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fischbach?
Aye.
Ms. Fischbach votes aye. Ms. Spartz? Ms. Spartz votes yes. Mr. FitzGerald? Mr. Benz?
Mr. Benz votes aye.
Mr. Benz votes aye. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
Has Mr. Buck been recorded?
Mr. Buck, you are not recorded.
I vote no.
Mr. Buck votes no.
Are there any other members who wish to vote who haven't voted? Clerk will report.
Mr. Chairman, there are 13 ayes and 24 noes.
And the amendment is not agreed to. For what purpose does Ms. Jackson-Lee seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4445, offered by Ms.
Without
Jackson.
objection, the amendment is considered as read, and the sponsor is recognized for 5 minutes for the purpose of explaining the amendment.
Mr. Chairman, thank you so very much. And let me start again by thanking the sponsors of the bill. Delighted to be a co-sponsor, and Congresswoman Jayapal, and Bustos, and Cicilline, and of course the Judiciary Committee, and admit again that we are doing a very historic legal change to provide rights for individuals who have heretofore been forced to accept one choice, forced arbitration. And as I started out earlier today, this morning, forced arbitration is in essence the privatization of the justice system. It stops a violated woman or someone else that is abused from getting into the courthouse. And I realize as well that this has come out of the Senate Judiciary Committee by a unanimous voice vote. But I believe this language speaks specifically to what the authors of the legislation intended. And I say that because one of the witnesses clearly would be an exhibit or an example for this amendment. The witness who, as I said, is still employed with the abuser. The abuser is still there, the witness is still there, and as she left our hearing yesterday, she was still an employee, still obligated to go to work, although, as she indicated, she was suffering from PTSD and was involved in medical care. My amendment simply says that the retaliation goes through the sections on page 2, where we list A, B, C, and D. Indicates retaliation for reporting, testifying, assisting, or participating in any manner in any investigation, proceeding, or hearing related to the conduct listed in the paragraphs. And so the retaliation that is there now speaks only to the rejecting of unwanted sexual attention when there are other elements, unwelcome sexual advances, unwanted physical contact, and unwanted sexual attention. The idea is to ensure that if any of these aspects of this is in any way used to retaliate, that it would be protected under this law. And so I ask my colleagues to note that I am viewing this bill as a very good bill and as a bill that is going to make history for those who will impact. My effort was to ensure that any aspect of what this victim would do, whether it was reporting or testifying, as was done yesterday, or assisting or participating in any investigation proceeding, that they would be protected from retaliation. Mr. Chairman, with that, I yield back.
The gentlelady yields back. For what purpose does Ms. Jayapal seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I want to thank my colleague from Texas, who is always incredibly thoughtful about what she proposes and very learned about all of the issues that we debate. And I know she knows that this bill has gone through, it's what I said to Congressman Buck as well, that this bill has gone through extensive negotiation with the Senate. And so changing it, not that there perhaps wouldn't be opportunities if this were starting in the House, but given that it has gone through the Senate, given that it is bipartisan and bicameral, I would just say that we very much appreciate the amendment, but hope that my colleague would understand that this is a carefully negotiated agreement, and we hope that we can continue to work together in the future to make sure that all of these issues are addressed, but would be very grateful if my colleague would consider withdrawing the amendment. Thank you, Mr. Chairman. Yield back.
The gentlelady yield?
Yes, I do.
I think it is an important fix for the legislation. I know that there are organizations who are part of negotiation, trial lawyers who believe this is an important fix. I would look forward to us having the opportunity, as has been said earlier, by working our way through to the floor, because I want to make sure that the very profound example of the witness who is still employed, who is now testifying. As of yesterday, she was not terminated, fearful of such. I think I can say her name is Newton. I've tried not to. And I thought that this needed to be precise. But I am willing to work with the gentlelady and the chairman going to the floor, and I would be happy at this time to withdraw the amendment. I ask unanimous consent to withdraw the amendment.
Appreciate that so much. Thank you.
Objection.
Thank the gentlewoman.
Without objection. The amendment is withdrawn. Okay, if there are no further amendments, the question occurs on the amendment and the nature of a substitute. This will be followed immediately by a vote on the final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no.
Aye.
In the opinion of the chair, the ayes have it. The amendment and nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 4445 as amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably.
Mr. Chairman, request a recorded vote.
Recorded vote has been requested, and the clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee? Aye. Ms. Jackson-Lee votes aye. Mr. Cohen?
Aye. Aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch?
Okay.
Ms. Bass?
Bass votes aye.
Ms. Bass votes aye. Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Proudly aye.
Ms. Jayapal votes aye. Ms. Dimmings?
Aye.
Ms. Dimmings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Dean votes aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones?
Aye.
Mr. Jones votes aye. Ms. Ross?
Aye. Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnston of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany?
Okay, sorry for the interruption.
No problem. We are really.
Mr. Tiffany votes no.
And taking into account that I've seen
Mr. Massey?
Massey votes no.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Ms. Sparts votes no. Mr. FitzGerald? Mr. FitzGerald votes no. Mr. Benz?
Benz votes no.
Mr. Benz? Mr. Benz?
Votes no.
Mr. Benz votes no. Mr. Owens?
Owens, no.
Mr. Owens votes no.
Mr. Chairman, how am I recorded?
Mr. Deutsch, you are not recorded.
Aye.
Mr. Deutsch votes aye.
Madam Clerk, how am I reported?
Mr. Johnson of Georgia, you are not recorded.
Vote aye.
Mr. Johnson of Georgia votes aye.
Are there any other members who wish to vote who haven't voted? Clerk will report.
Mr. Chairman, Congressman Issa, how am I reported?
Mr. Issa, you are recorded as aye.
That's a no.
Mr. Issa votes no.
Mr. Chairman, how am I recorded?
Mr. Stube, you recorded as aye.
No.
Mr. Stube votes no.
Are there any other members who wish to vote who haven't voted yet? The clerk will report.
Mr. Chairman, there are 27 ayes and 14 noes.
The ayes have it, and the bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 612, the Downwinders Parity Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 612, to amend the Radiation Exposure Compensation
Without
Act.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Introduced by our Judiciary Committee colleague, Representative Greg Stanton, H.R. 612, the Downwinders Parity Act of 2021, would update the geographical reach of the Radiation Exposure Compensation Act, or RECA, which provides compensation to certain individuals who lived downwind of atmospheric nuclear tests, people known as downwinders. Specifically, the bill would include the southern parts of Clark County, Nevada, and Mojave County, Arizona, in the program. Currently, only the northern parts of these counties are covered under RECA, and these counties are the only ones to be partially covered under RECA. Enacted in 1990, RECA established an administrative claims program within the Department of Justice to provide partial restitution and compassionate compensation to individuals who were harmed by atmospheric testing of United States nuclear weapons and the timing operations that produced the necessary, and the mining operations that produced the necessary uranium ore. To be eligible for compensation under RECA, a person must have been an on-site participant, lived in certain covered downwind counties during a specified time period, or worked as a specified category of uranium mine worker for a certain period of time prior to 1971. In addition, an individual must have contracted certain specified illnesses associated with radiation exposure. Starting in the 1940s, with the development of the atomic bomb during World War II, the U.S. government embarked on a decades-long program of nuclear weapons testing and development. In the continental U.S., atmospheric testing occurred primarily, but not exclusively, at the Nevada test site, where the federal government conducted 100 atmospheric tests during the 1950s and early 60s, before the U.S. signed the Limited Nuclear Test Ban Treaty in 1963. Coinciding with much of this period was an increase in uranium mining. Thousands of U.S. uranium mine workers, many of whom were Native American, labored to produce the raw materials needed to fuel U.S. atomic weapons development. During much of this period, the U.S. government oversaw many mining operations and was the sole purchaser of uranium ore. The U.S. government stopped purchasing uranium for atomic weapons in 1971. The federal government was aware of the potential hazards associated with atomic weapons testing and uranium mining, but it failed to warn or adequately protect affected individuals and communities. Through a series of court rulings, those who had been harmed by the federal government's actions with respect to atomic weapons testing were unable to obtain a remedy for their injuries through the judicial system. In response, and in acknowledgement of the federal government's responsibility, Congress passed RECA over 30 years ago and expanded its scope further in 2000. The legislative record, however, is unclear as to why Congress excluded downwinders residing in the lower portions of Clark County, Nevada, and Mojave County, Arizona, from RECA, despite their proximity to the Nevada test site during the covered periods. Given this apparent lack of clarity, their exclusion from RECA seems particularly arbitrary. By adding the southern parts of these counties to the program, H.R. 612 is a long overdue but modest update that would correct the statutory anomaly. Indeed, at a hearing held this past March, the Subcommittee on the Constitution, Civil Rights, and Civil Liberties heard testimony from Jean Bishop, a Republican member of the Mojave County Board of Supervisors, attesting to the impact of atmospheric nuclear testing on the health of her family and others like hers in the community she represents. I would also note that beyond Clark and Mojave counties, many other downwinders and uranium mine workers affected by the U.S. government's conduct related to atomic weapons testing and development remain ineligible to receive compensation under RICA. Many of these individuals are arguably also similarly situated to others currently eligible under RICA, yet they have been denied the chance for compensation, despite the continuing negative impacts of the government's atomic weapons development on their health. I want to make clear that the committee's consideration of H.R. 612 is not the last word on RICA. Today's markup does not preclude the committee from considering other legislation proposing additional expansions and reforms to the RICA program at a later date. I'd like to thank our colleague, Representative Stanton, for introducing this important bill and for his leadership and persistence in advocating for the people this legislation would serve. I urge my colleagues to support it. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Congress passed the Radiation Exposure Compensation Act, or RICA, in 1990 to provide restitution to individuals who got sick as a result of exposure to radiation back when the United States government was testing atomic bombs between 1945 and 1963. The goal of Congress in 1990 was to provide compensation to people whose health ailments can be reasonably determined to come from the U.S. government's actions. This intention can be seen in the one-time nature of the payments and in the specific geographic time and disease requirements for compensation. Congress last extended and expanded RICA in 2000. At that same time, Congress commissioned a study to examine whether to expand the eligibility to the so-called downwinders. In 2005, the National Academy of Sciences, Engineering, and Medicine completed its study looking at the effect of nuclear weapon tests on the health of surrounding populations. This study concluded that Congress should not simply expand eligibility in RICA, but based on geography alone, as the study explained, quote, the scientific evidence indicates that in most cases it is unlikely that exposure to radiation from the fallout was a substantial contributing cause to developing cancer. This bill, however, expands eligibility based on geography alone. It would add portions of Nevada and Arizona to the program's coverage. No one here disputes that if the federal government recklessly took actions that led to our citizens getting cancer, they should have access to a remedy. We all agree with that. That's why Congress passed this law in the first place in 1990 and why it extended it in 2000. But based on what we now know, or what we know now, I should say, the science simply does not support the assertion that the program should be expanded solely based on geography. I know we have Mr. Owens, who has strong thoughts on this as well. But Mr. Chairman, I thank you, and I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment to H.R. 612 offered by Mr. Nadler.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment simply amends the reporting requirement in Section 3 of the bill to shorten the deadline for the Attorney General to send the required report to Congress from 180 days after enactment to 60 days. It makes no other changes to the bill. I urge members to support the amendment. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Mrs. Stanton seek recognition?
Thank you, Mr. Chairman. Earlier this year, the Subcommittee on Constitution, Civil Rights, and Civil Liberties held a hearing entitled Examining the Need to Expand Eligibility under the Radiation Exposure Compensation Act. And I was grateful to Chairman Cohen and Ranking Member Johnson for holding that important hearing. I did have the opportunity to testify at that hearing, as it was the first time in 20 years that a potential expansion of RICA had been heard in the House of Representatives. Well, today marks another important day. Today marks progress. Today, this committee will take another step toward providing justice to those who are exposed to harmful, cancer-causing effects of radiation by their federal government, people we know as downwinders. I'm proud to sponsor H.R. 612, the Downwinders Parity Act of 2021, a bill that has earned bipartisan support for more than a decade. And I want to thank Chairman Nadler for bringing this bill to the full committee today for a markup. Beginning in 1945, as part of our nation's defense strategy, the federal government conducted atomic testing in remote regions of the southwestern United States. During the government's atomic testing period, our nation conducted 1,054 atomic tests in total, 928 of which was carried out at the Nevada test site. And 100 of those tests were atmospheric tests, when atomic weapons were exploded above ground, causing radioactive materials to be released into the atmosphere and spread to other states. As a direct result of that exposure, and as a cruel legacy of the Cold War, too many Americans developed cancer, suffering those illnesses, and died for the sake of our national security. As a remedy in 1990, the Radiation Exposure Compensation Act, or RECA, was enacted to provide cash benefits to individuals who participated in that testing, like uranium miners, millers, and ore transporters, as well as those who lived in nearby communities which were downwind from the Nevada test site. Unfortunately and inexplicably, some of the most harmed communities were left out of RECA, as the borders of the defined, quote, affected area, unquote, cut through two of the counties closest to the Nevada test site, Clark County, Nevada, and Mojave County, Arizona. The side effects of radiation exposure are well documented, and a real-world example has played out in Mojave County, Arizona. According to a report published in July 2020 by the Arizona Department of Health Services, Mojave County has the highest age-adjusted rates of invasive cancer and the highest mortality rates from cancers of any county in our state. Yet, only the northern portion of Mojave County is included in the affected area for downwinders. In Nevada's Clark County, only the northeastern most townships are included in the affected downwind area, despite the county virtually sharing a border right next to the Nevada test site. The lower portions of both of these counties have been ravaged by cancer, and too many families have lost parents, siblings, loved ones, while the federal government has turned a blind eye. As the RECA Trust Fund is set to expire in July of next year, it's time for Congress to act before it's too late, to provide just compensation to communities still affected by atomic testing. Now, earlier I said this committee was taking an important step forward today, and it certainly is. But as the chairman said, this is likely not the last step Congress will take toward RECA reform. Many members of this committee, and I'm one of them, co-sponsor a bipartisan, bicameral bill which would reauthorize the RECA Trust Fund, expand the affected downwind area to multiple states, and extend the eligibility dates for uranium workers. These are big, important goals for RECA and reforms that I hope to continue to work with my colleagues to achieve. Given the current political climate and the cost of such measures, I anticipate that reform will require intense negotiation, budget scrutiny, and hours of legislative time. That's time the residents of Clark County and Mojave County do not have. My bill will set those legislative wheels in motion and right such a terrible wrong that was made so long ago. The Downwinder Parity Act of 2021, before us here today, would extend downwinder eligibility to those who were present in Lower Clark County and Lower Mojave County during a period of atmospheric testing at the Nevada test site. These Americans deserve justice for their illnesses caused by the government's atomic testing, and they deserve action from this Congress. Thank you again, Mr. Chairman, for bringing this bill for markup today. I look forward to a successful passage on the House floor, and I would like to ask unanimous consent to enter 3 items into the record: a letter from the Intertribal Council of Arizona, a letter from the Tri-City Council of Arizona, and a resolution from the City of Kingman, Arizona.
Without objection.
I yield back.
Gentleman yields back. For what purpose does Mr. Owen seek recognition?
Thank you, Mr. Chairman. I'd like to begin by expressing thanks to my colleague from Arizona, Representative Stanton, for working on the downwinders issue. Clark County, Nevada, and Mojave County, Arizona are important downwinders areas to include in the RECA discussions. However, data from the National Cancer Institute shows that the downwinder area should include other geographical areas above and beyond what is currently included in the RECA. The study, which was published in September of 2020, shows that at least 5 counties in New Mexico that surrounded the Trinity site should be added. In addition to the inclusion of other downwinder geographical areas, there are other classifications of radiation exposed victims whose situations must also be addressed. For example, studies have shown that uranium miners that worked in the mines after December 31st, 1971 are having the same physical maladies to the same extent that uranium workers and miners who worked previously to that cutoff date are suffering. There are also a lot of medical conditions that are not included in the original law or in the amendments of 2000, for which new medical data shows should include, like renal cancer and renal failure in uranium workers. I promised my constituents that I would be an advocate for downwinders. This is a problem created by the government that the government must resolve sooner versus later. But I must reluctantly vote against HR 612 because the scope is too narrow. We must focus on all downwinder victims. As a lead Republican sponsor to HR 5338, the RICA Amendment Act, I would enjoy working with Mr. Stanton on this issue. HR 5338 will extend the existing RICA program for 19 years. It would also expand eligibility compensation to cover additional diseases in communities that were previously left out. We need to make sure that we don't let this program expire and that we include all the communities that were harmed. I'll work to make sure that Clark County and Mohave County workers are included and that other folks harmed by this process are also acknowledged and assisted. I urge the chairman to mark up this bipartisan legislation as soon as possible this year. Thank you, and I yield back.
The gentleman yields back. For what purpose does the gentleman from Tennessee seek recognition?
Thank you, Mr. Chairman. This is
Move
important.
to strike the last word.
I do move to strike the last word and several
Gentleman is
others.
recognized.
I appreciate the work of Mr. Stanton and the work of Mr. Lujan, Senator Lujan. They've done extraordinary work looking out for their constituents. We had the hearing in the subcommittee that I chair. We had the witnesses as the chairman laid them out, and they gave a story that was compelling, and it made no sense that the geographic borders, that the counties, half the counties were in the zone and half weren't in the zone, as if the nuclear waste had any idea where the county borders were or where they should be. So this is an important and scientifically based understanding of where the damages were and needs exist. So it's an important bill. We need to pass Senator Lujan's bill as well in the future, and hopefully it'll come up. That's an important bill as well, and I'm sure Mr. Stanton supports it as well, and it'll bring about justice in those areas. Otherwise, I just urge passage of the legislation and applaud Mr. Stanton and Mr. Lujan for their outstanding work on behalf of their constituents. Yield back the balance of my time.
The gentleman yields back. Who seeks recognition? For what purpose does the gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady is recognized.
Let me let Mr. Stanton know that this really impacts just a wide range of communities, and this expansion by you and extension is a very important step to recognize that there is perimeter and extended parameter impact on individuals and communities that live within the distance of chemical plants, in this instance, the old-fashioned nuclear explosions of the 1950s. And so I want to congratulate you for HR 612, the Downwinders Parity Act of 2021, which updates the downwinder eligibility area under the Radiation Exposure Compensation Act. I think that most people would not know how naive persons were in the midst of these explosions. And the RICA provides compensations to individuals with cancers and other health conditions resulting from the testing of atomic weapons at the Nevada test site from 1945 to 1960. That was a very, very long time. And though monies have been paid out to 37,000 claims, I just want to offer some of the descriptions that indicate how individuals, from the stories of those who lived there, we know that families would gather for bomb parties where they would stand on their front porches with neighbors or ride on horseback out into their fields and watch the big orange mushroom clouds in the distance. Who would think? Who would know? Who would have the knowledge of how dangerous, how killing this was? We know that children would catch falling radioactive ash on their tongues as though it was snow. We know that uranium mine workers were never informed of the potential harms of radiation exposure. And we know that because of this radiation exposure, men and women in this area regularly developed cancer and other deadly health issues by the time they were 40 years old. And so those who were within win districts, if you will, had the same kind of effect. And the U.S. government chose secrecy over the well-being of American citizens, and it cost these citizens, in many instances, their lives, their futures, and their economic security. So I want to acknowledge that there are communities that have similar circumstances right in 2021. But to fix this is long overdue, and I believe the leadership, Mrs. Stanton, should be commended, the chairman of the Subcommittee on Constitution, Mr. Cohen, and that we should move expeditiously to pass H.R. 12, the Downwinders Parity Act of 2021. I yield back.
The gentlelady yields back. Are there anyone else wishes to speak? In that case, the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote and final passage of the bill. All those in favor respond by saying aye.
Aye.
Opposed, no.
Because
In
of fears.
the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 612 as amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably. A recorded vote has been requested. The clerk will call the roll.
Yes.
Mr. Nadler.
Go ahead,
Aye.
Judy.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch.
Okay. Yeah, so, so call me around
Ms.
1 o'clock.
Bass.
Bass votes aye.
Hank, turn off.
Ms. Bass votes aye. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin. Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Stimmings.
Aye.
Ms. Stimmings votes aye. Mr. Correa.
Aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Steen.
Dean votes aye.
Ms. Steen votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones. Ms. Ross.
Ross votes aye.
Ms. Ross votes aye. Ms. Bush.
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan. Mr. Jordan votes no. Mr. Shabbat.
No.
Mr. Shabbat votes no. Mr. Gomert. Mr. Gomert votes yes. Mr. Issa.
No.
Mr. Issa votes no. Mr. Buck.
No.
Mr. Buck votes no. Mr. Gates. Mr. Johnson of Louisiana. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock. Mr. McClintock votes no. Mr. Stubbe.
No.
Mr. Stubbe votes no. Mr. Tiffany.
Tiffany votes no.
Mr. Tiffany votes no. Mr. Massey?
Massey votes no.
Mr. Massey votes no. Mr. Roy? Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Ms. Sparts votes yes. Mr. FitzGerald? Mr. Benz? Mr. Benz votes no. Mr. Owens?
Owens, no.
Mr. Owens votes no. Mr. Gates, you are not recorded. Mr. Gates votes no.
Mr. Chairman, how am I recorded?
Mr. Deutsch, you are not recorded.
Aye.
Mr. Deutsch votes aye.
Are there any other members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 25 ayes and 13 noes.
The ayes have it, and the bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 1621, the Prohibiting Punishment of Acquitted Conduct Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1621 to amend Section 3661 of
Without
Title
objection,
18.
the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 1621, the Prohibiting Punishment of Acquitted Conduct Act of 2021, is an important measure to end the practice of federal judges increasing sentences based on conduct for which a defendant has been found not guilty by a jury. This bill, introduced by Steve Cohen, the chair of the Constitution, Civil Rights, and Civil Liberties Subcommittee, specifically prohibits the consideration of acquitted conduct at sentencing, if not for mitigation purposes. In order to convict any defendant of a crime, the Constitution requires that the government prove that defendant's guilt beyond a reasonable doubt. The Sixth Amendment right to a trial by jury and the Fifth Amendment's Due Process Clause require that each element of a crime charged against the defendant be either admitted by the defendant or proven to the jury beyond a reasonable doubt. Despite these foundational guarantees, federal law allows judges, in effect, to override a jury's verdict of not guilty and to sentence defendants for acquitted conduct. Current law bars any limitation on the conduct that a sentencing court may consider for the purposes of imposing punishment, and the relevant conduct provision of the U.S. sentencing guidelines allows a sentencing court to consider a range of factors, including acquitted conduct. Based on this guidance, federal judges may enhance sentences if they find, by preponderance of the evidence, a lower evidentiary standard than required at the guilt-innocence phase, that a defendant committed other offenses. This practice is fundamentally unfair, and as Justice Scalia said in Jones versus United States, this has gone on long enough. This legislation amends current law to preclude judges from considering acquitted conduct, except for the purpose of mitigating a sentence. The bill will make sure that defendants are punished only for the conduct that prosecutors are able to prove at trial, consistent with the constitutional guarantees of due process and the right to a trial by a jury of their peers, and consistent with the principles on which this country was founded. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. I'm going to just abbreviate my remarks and just read a couple sentences here. As you indicated, this is a good bill. The late Justice Antonin Scalia wanted this practice to end, this practice of using acquitted conduct at sentencing. So has current Justice Brett Kavanaugh. In 2015, when he was judge for the U.S. Court of Appeals for the D.C. Circuit, Judge Kavanaugh said this, quote, allowing judges to rely on acquitted or uncharged conduct to impose higher sentences than they otherwise would impose seems a dubious infringement on the rights of due process and to a jury trial. I couldn't agree more. I agree with both Justice Scalia and Justice Kavanaugh. We should support this legislation and pass it as soon as we can. I yield back.
The gentleman yields back. Are there any amendments to H.R. 1621? For what purposes does Mr. Cohen seek recognition?
Thank you. Strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to begin by thanking my colleague, Congressman Kelly Armstrong, an outstanding member of this committee in the last Congress, who we regret is not here this year because he was an outstanding member. He worked on this issue and really brought it to the fore, and I was proud to join with him on it and partner with him on H.R. 1621. This bipartisan, bicameral effort to prevent judges from punishing defendants for conduct they've been found not to be guilty of. The Constitution guarantees the right to due process and the right to a trial by jury, two of the foundational principles of the American criminal justice system and what we call rule of law. These rights ensure that we are presumed to be innocent unless and until the government proves the defendant's guilt guilt beyond a reasonable doubt. That standard is what we have, guilt beyond a reasonable doubt. However, under federal law, judges may impose sentencing enhancements for conduct based on a lesser standard preponderance of the evidence. The result of this discrepancy is that law is that even if a defendant has been found by a jury that appears to be not guilty of a crime, the judge may still use and consider that conduct. As the ranking member said, Justice Scalia was against this, Justice Kavanaugh was against this, Justice Ginsburg was against this. Ginsburg and Scalia had often paired together and came to the same conclusions. And I think Justice Thomas was as well. So this is, I think, a proper change in the law for justice and fairness, and antithetical to the foundational principles of our criminal justice system to do otherwise, undermining due process and the function of jury trials in our legal system. The Bipartisan Bicameral Prohibiting Punishment of Acquitted Conduct Act of 2021 would right this wrong, prohibiting the consideration of this acquitted conduct and sentencing by federal judges. It does so by amending Section 3661 of Title 18 to expressly state that, except for purposes of mitigating a sentence, a court of the United States shall not consider acquitted conduct when considering sentencing a defendant. Any consideration of acquitted conduct is and should be a bipartisan effort, and we've seen that it is here today. And Kelly Armstrong and Justice Scalia, two wonderful examples of that. Allowing justice to continue to sentence is wrong. We need to get around it and get away from it. Ask my colleagues to join me in supporting the bill. Thank you very much. I yield back the balance of my time. I do have before I yield back the balance of my time, I'd like to retract that. I'd like to enter into the record a letter to the committee from 22 supporting organizations for passing this bill, and without objection.
Without objection.
Now I yield back the balance of my time.
Gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
I'd strike the last word.
Gentlelady is recognized.
Mr. Chairman, I want to congratulate my friend and colleague, Congressman Cohen, and of course his co-sponsor, Congressman Armstrong, a very fine member that was with us and still seeks to work with us going forward. I'm delighted that the committee is considering H.R. 1621, the Prohibiting Punishment of Acquitted Conduct Act, and as chair of the Subcommittee on Crime, Terrorism, Homeland Security, we're pleased to have this as one of the legislative successes of our colleague, Mr. Cohen. And we are providing a solution to a long-identified problem within our criminal justice system. This bill provides necessary reform to current federal sentencing practice that allows judges to sentence defendants based on conduct for which a jury found them not guilty. I think people would be stunned by that act, but that is what happens. The Sixth Amendment to the Constitution provides that anyone accused of a crime shall enjoy the right to a speedy and public jury trial, while the Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law. Together, these provisions mean that the government is bound to prove each and every element of an offense for which a defendant is charged beyond a reasonable doubt during a jury trial, or that a defendant must admit each element to support a plea of guilty. Notwithstanding this constitutional obligation, federal judges routinely nullify not guilty verdicts rendered by juries and sentence defendants to significantly higher penalties based on acquitted conduct. Stunning again. In its current form, 18 U.S.C. 3661 prohibits any limitation of the conduct a judge may consider when sentencing a defendant, even when a jury has determined that there was insufficient evidence to prove the defendant committed a charged offense. Additionally, under the concept of relevant conduct, the sentencing guidelines allow judges to consider a range of conduct, including dismissed charges, uncharged conduct, and acquitted conduct. The fact-finding made by judges at sentencing is based on a lower evidentiary standard than at trial. That is by a preponderance of law, which many scholars define as a 50% chance that a claim is true. The reform proposed in this bill ensures that judges punish defendants based on facts proven beyond a reasonable doubt. The higher evidentiary standard of proof required during jury trials, which some scholars attach a value of 90 to 95% surety. As the chairman previously stated, Justice Ginsburg, a moderate liberal who became more liberal in later years, joined Justice Thomas, Justice Scalia, a staunch conservative, in his consent in Jones versus United States, lamenting the failure of the court to determine if the Sixth Amendment is violated when judges impose sentences based solely on judge-found facts. Justice Scalia's often quoted dissent was issued 7 years ago, yet nothing has been done about this unjust, undemocratic practice, which diminishes the sanctity of the jury trial, the public check on the government's power, and the overall integrity of the criminal justice system until now. H.R. 1621 would restore fairness to jury trials by amending Section 3661 to ban consideration of acquitted conduct at sentencing unless the conduct is considered for mitigation purposes. While I wish we were doing more today to advance the standard of criminal justice reform, I support this bill that addresses an acute need while restoring the basic proposition of due process and the right to trial by jury. I commend and congratulate Representative Steve Cohen, Representative Kelly Armstrong for their work on this bipartisan bill. As I said, long overdue, and I urge my colleagues to support this bill and to continue to work on additional measures to make our justice system more equitable and more transparent. That, Mr. Chairman, I yield back.
The gentlelady yields back. For what purpose does Mr. Shabbat seek recognition?
Move to strike last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. I'll be very brief. It's getting late in the day. I want to thank Mr. Cohen and Mr. Armstrong for their leadership in crafting this legislation. Due process is a right guaranteed to all citizens under the Constitution. I was going to quote Justice Scalia, but Mr. Jordan already did, so I won't repeat that. One of our greatest justices of all time, I would say. Over the years, some federal judges have enhanced the sentencing of convicted criminals based upon alleged conduct for which they were acquitted. That's just not right. I think it violates the 6th and 14th Amendments of the Constitution. This is common sense legislation. I urge my colleagues to support it, and I yield back.
Gentleman yields back. For what purpose does Mr. Cicilline seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I want to thank you for bringing this important bill to markup, and I want to thank Representative Cohen for his leadership and Representative Armstrong for joining him in introducing this bipartisan, bicameral legislation that will restore, Chairman Cohen, a key aspect of fairness to our criminal justice system. It's a principle in our justice system that you're innocent until proven guilty. A complement to that principle is that due process ensures that before you receive punishment for a conviction, you're entitled to a trial by a jury of your peers. If they find you innocent, the case is finished. It is un-American to punish someone for a crime once they have been found not guilty of that crime, but that is exactly what is happening in sentencing hearings all across this country. Congress has allowed judges a wide array of discretion in imposing sentences. Judges can consider various factors, including whether the defendant has committed the same crime before, whether the defendant is remorseful, and the nature of the crime itself. Some of these considerations make sense. What does not make sense is allowing consideration of an offense for which that person has been acquitted. For a person to be convicted of a crime, a prosecutor must prove beyond a reasonable doubt that they actually committed that crime, a concept we and any American who watches Law and Order is familiar with. And so it goes against common sense that under current law, a jury can find you innocent or find you not guilty, but down the line, if a judge disagrees with that ruling, they can impose a punishment anyway, effectively overturning an acquittal and the presumption of innocence until proven guilty. This is absurd. This vital bill will end the practice of judges increasing sentences based on conduct for which a defendant has been acquitted by a jury, restoring the pillar of fairness in our criminal justice system that a jury acquittal can fairly be relied upon. I want to end where I began by thanking Congressman Cohen and Congressman Armstrong, Chairman Cohen, excuse me. and Congressman Armstrong as well for their leadership on this issue, and I urge my colleagues to support this common sense bill today, and I yield back, Mr. Chairman.
Does anyone else seek recognition? In that case, the question occurs on the bill. All those in favor say aye. Aye.
Aye.
Opposed, no. In the opinion of the chair, the ayes have it. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 5720, the Courthouse Ethics and Transparency Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
HR 5720 to amend the Ethics and Government Act of 1978.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 5720, the Courthouse Ethics and Transparency Act of 2021, is an important bipartisan effort to address an alarming lack of transparency in the personal financial holdings of federal judges and the conflicts or appearance of conflicts those holdings can create in the cases those judges are asked to decide. This legislation makes incremental but necessary progress toward accountability by building on federal statutes that already prohibit judges from deciding cases in which they have a personal financial stake in the outcome. It has been the law in this country since the 1970s that judges must recuse themselves from any case in which they hold a legal or equitable interest of any size in any party or property under consideration. To help ensure that recusals occur as required, federal law also requires judges to file annual reports disclosing their personal financial interests so that litigants, the press, and the general public can check their work. Unfortunately, recent reporting by prominent media outlets and a hearing by the court subcommittee have shown that the law is not working as intended. The infrequency of judges' financial disclosures and the inaccessibility of the reports themselves have made actual transparency practically impossible. The result is recent investigative reporting revealing that over 130 federal judges have decided cases in which they are part owners of the parties before them. Over 60 judges have actively traded shares in the parties in their courtrooms while their cases are still going on, in some cases profiting in those trades. H.R. 5720 addresses these problems by requiring federal judges to abide by the same periodic transaction reporting laws already applicable to members of Congress and senior executive branch officials. Further, the bill requires the Administrative Office of the United States Courts to create an online database of judicial financial disclosure reports and to timely update that database with searchable, sortable, and downloadable copies of disclosure reports as they become available, so that litigants, the press, and the public can access and analyze that information in close to real time. I want to thank Congresswoman Ross for her leadership on this issue and for introducing this legislation. I also want to thank Hank Johnson, Chairman of the Subcommittee on the Court's Intellectual Property and the Internet, for holding a hearing exposing the issues this bill addresses, and Mr. Issa, the ranking member of the subcommittee, for his collaboration both on that hearing and on this bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. The Courthouse Ethics and Transparency Act of 2021 is about bringing more transparency to the federal judiciary, requiring judges to periodically report securities transactions. As I think we all know, that members of Congress have to do this. It seems that folks in the executive branch should do the same. The Wall Street Journal investigation revealed that between 2010 and 2018, 131 federal judges failed to disqualify themselves from 685 cases in which a stock they or their family owned was a plaintiff or defendant. This is troubling and could give rise to perception of impartial judges. In this country, there should be no doubt that judges are acting without prejudice, especially with respect to their own personal finances. The legislation is a thoughtful and responsible step towards a more transparent government, and maybe more importantly, the bill ensures that certain personal and sensitive information, or as importantly, I should say, the personal information about judges is not made public as part of the required disclosures. Just one note for the record, though, however, the Judicial Conference has not taken a position on this bill. We should be prepared to consider feedback from them and other stakeholders who may spot some concerns as the bill moves forward. But I think this is a good piece of legislation. I, too, want to commend the sponsors and Mr. Issa and the Democrat sponsors of the legislation. Pending future unforeseen issues, we should be supporting this, and I hope my colleagues will do the same.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to HR 5720.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment in the nature of a substitute makes technical changes to the bill's short title, removes the legislative findings, and makes a handful of non-substantive changes for clarity. These minor changes do not impact the bill's operative provisions aimed at improving transparency and accountability of judges' financial disclosures, and I urge all members to support the amendment. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Ms. Ross seek recognition?
Mr. Chairman, I move to strike the last word.
The gentlelady is recognized.
Thank you, Mr. Chairman, and I'd like to thank Representative Issa, Mr. Chairman Nadler, Chairman Johnson, and Representative Roy for working with me on the Courthouse Ethics and Transparency Act. This bipartisan bill will make federal judges more accountable and restore confidence in our federal judiciary. As you heard from Ranking Member Jordan, the Wall Street Journal's recent investigation exposed the weaknesses of our current judicial ethics and recusal laws. It found that over 130 federal judges presided over cases where they had a financial stake. Some judges even actively traded litigants' stock during trials they presided over. Their actions threaten the trust litigants place in judges as impartial and disinterested arbiters of justice and the institutional legitimacy of our courts. One such litigant, Ms. Sherry Cheshire, whose husband Jim served in this country's military for 24 years, died of mesothelioma. I can't say that word. Their wrongful death suit was effectively ended by a judge who owned at least $15,000 worth of shares in each of two of the defendants in that case. The Journal's reporting was not the first to document the shortcomings of our judicial recusal system. If this committee fails to act, it will not be the last. We must pass the Courthouse Ethics and Transparency Act to strengthen judicial ethics and transparency and to restore trust in our nation's court. This bill will ensure that federal judges face the same financial transaction disclosure requirements as members of the legislative and executive branches of government. The double standard that currently exists for members of the judiciary is unwarranted and should be eliminated. This bill also requires the online publication of judges' financial disclosures on a publicly accessible and searchable database. This is the same as the current requirements for members of Congress and senior executive branch officials. The online database will add another layer of protection from potential conflicts of interest. It would allow litigants and watchdogs to identify conflicts sooner, instead of solely relying on the ineffective processes currently in place or simply on the judges themselves. Furthermore, the personal safety of federal judges and their families cannot be compromised. That's why this bill preserves the existing confidentiality rules that enable judges to redact personal and sensitive information that could endanger them or their family members. To be clear, the online database will not include any information that is not already publicly available. The Courthouse Ethics and Transparency Act will increase transparency, accountability, and trust in the American promise of blind justice. For that reason, I urge my colleagues to support the bill, and I yield back.
For what purpose does Mr. Johnson seek recognition?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. I want to recognize Congresswoman Ross and Congressman Issa, my colleagues on my subcommittee, for championing this bill. H.R. 5720 will close two loopholes in the Ethics in Government Act that contributed to dozens of federal judges violating federal law by presiding over cases in which they had a financial interest, holding federal judges to the same, financial disclosure standards that apply to every other federal official will ensure that litigants and the public will be able to identify for themselves whether a judge must recuse from a case. But Congress has more work to do if we want to prevent the next Wall Street Journal expose. For example, the hearing we held last month on this topic made clear that we also need to strengthen the judicial recusal statute, convictions on judges owning or trading stock in individual companies, and ensure that the judiciary isn't exempted from other federal conflict of interest statutes that apply to legislative and executive branch officials. It might even be time for the committee to take a look at our former colleague, Mr. Sensenbrenner's bill that would create an inspector general for the judicial branch. My point is this: applying the Stock Act to judicial officers and requiring judicial branch financial disclosures to be posted online is a good start, but it won't be the last word. Finally, I hope that HR 5270 will help our federal judges move from what one witness at our hearing described as a culture of silence to a culture of compliance with their constitutional, statutory, and ethical obligations. The American people expect better from the judiciary, and the rule of law demands it. And with that, Mr. Chairman, I yield back.
The gentleman yields back. For what purpose does Mr. Issa seek recognition?
To move to strike the last word, Mr. Chairman.
The gentleman is recognized.
Mr. Chairman, I want to join with my subcommittee chairman in each and every one of the statements he made. The fact is that the executive branch, the judicial branch, and the legislative branch, we have something in common. We are all populated with men and women, with people who are no better, no worse than the population as a whole. And that means that when money, finances, personal activities affect someone's life, they can, on occasions, do something wrong. And if there's a chance that somebody who holds somebody's life in their hand, somebody's business in their hand, in fact, can be influenced, as does happen from time to time, then we have an obligation not only to prevent it if we can, as we have with the Stock Act and we have with the various disclosures, but also the appearance of impropriety, the chance that people would not trust the judges who hold their lives in their hands simply is too great a gamble. So notwithstanding some judges and some of the justices wishing that we would leave it to them, I think we have an obligation to harmonize the way we look at people in all three branches, hold no one above the law, no exceptions. And I believe that's what this legislation does. And I commend all those involved in supporting this legislation. I think we can move from this to additional compliance that I think is good for all. And I join with the recognition that the chairman, speaking of our former chairman, Mr. Sensenbrenner, his proposals, I think, are also worth dusting off and taking a good look at. And with that, I yield back.
The gentleman yields back. For what purpose does Mr. Cicilline seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Chairman Nadler, for bringing this important reform bill to markup today, and thank you to Congresswoman Ross for introducing this excellent legislation to bring greater transparency to the judges adjudicating cases every day. The Ethics in Government Act of 1978 requires most high-level government officials in all three branches, including federal justices and judges, to file annual financial disclosure reports. The 2012 Stock Act made these disclosures for members of Congress, as well as the President, Vice President, and other executive branch officials, readily available and searchable online. This makes the information easy for the American people to obtain, and this tool is vital to a well-functioning, transparent government. Federal judges and justices, however, are not subject to the Stock Act, and their disclosures remain relatively hidden. Under current law, judges' financial disclosure forms must be provided to any person that requests them. However, this process often takes months, delaying availability until months after it's really needed, and the disclosure is not given in a searchable format, making the information difficult to evaluate. A judge's impartiality is crucial to the integrity of any court case, which is why we have recusal requirements for judges who hold significant financial interest in the outcome of a case before them. However, despite these requirements, if we cannot accurately assess whether a judge even has such an interest, we cannot enforce the recusal requirements. While I'm sure many or most judges willingly recuse themselves from cases in which they have an interest, a Wall Street Journal investigation, which has been referenced, found that is certainly not always the case. The Journal's investigation found that since 2010, 130 federal judges have failed to recuse themselves in cases where they or a family member had a financial interest, which resulted in their ruling in almost 700 cases from which they likely should have been recused. Without accurate information publicly available, these kinds of personal interests may continue to drive judicial rulings and decisions unbeknownst to the public. Every time that happens, it erodes our justice system bit by bit and understandably makes the American people question whether the system can even be trusted. We have the power to create greater transparency in the judicial system, and today we take a major step towards doing that. This bipartisan bill would make the Stock Act reporting requirements applicable to judges and justices, making their final disclosures publicly available and searchable within 90 days of filing. This will allow the public to access these disclosure forms more easily, providing the information we need to ensure fair proceedings and necessary recusals. This measure is vital to a fair and transparent judiciary and will help restore the public's faith in our democratic systems. I thank Congressman Ross for introducing this extremely important legislation. I also want to thank Chairman Nadler, Congressman Johnson, Congressman Roy, and Congressman Issa for taking a lead on this important legislation as well. Transparency in our justice system should not be a bipartisan issue. This is a nonpartisan issue, and I encourage all of my colleagues across the aisle to support this important bill. Thank you, and I yield back the balance of my time.
Gentleman yields back. Does anyone seek recognition? Any amendments in the nature of a substitute? Any amendments? Question occurs on the amendment in the nature of a substitute. This will be followed by a vote on a final passage of the bill. All those in favor respond by saying aye. Aye.
Aye.
All those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. A reporting quorum, a vote on reporting H.R. 5720, the Courthouse Ethics and Transparency Act, a reporting quorum being present. The question is on the motion to report the bill H.R. 5720 as amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views without objection. The bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. We're now going to consider 2 codification bills en bloc. Pursuant to notice, I call up H.R. 5961 to make revisions in Title V, United States Code as necessary to keep the title current and to make technical amendments to improve the United States Code, and H.R. 5982 to make revisions in Title 51, United States Code as necessary to keep the title current and to make technical amendments to improve the United States Code. For purposes of markup and without objection, I move that the committee report en bloc the bills favorably to the House. The clerk will report the bills.
H.R. 5961 to make revisions in Title V, United States Code as necessary to keep the title current and to make technical amendments to improve the United States Code.
Without objection, the bills are considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. Over the course of this year, the Judiciary Committee has passed several bills developed by the Office of Law Revision Counsel to update and recognize the United States Code, which contains all of the general and permanent laws of the United States. This work ensures that our federal laws are accessible both to the government officials who work to fairly administer them and to the private citizens who seek the benefits or relief the laws provide them. We are grateful for all of the painstaking work that the expert attorneys at the OLRC have put in to draft this legislation while maintaining impartiality as the legislative policy. To date, 25 of the Code's 54 titles have been enacted into positive law, which means that the text of these titles is itself the law, while the remaining titles are non-positive, meaning that they organize federal statutes for use as convenience but do not themselves have the force of law. Today, we're taking up two bills that represent recent efforts by OLRC to keep positive law titles in the code up to date. Because the positive law titles are the law itself, they must be amended as by law, then Congress passes new statutes that belong within the titles because of their subject matter. The first bill, H.R. 5961, introduced by the gentleman from Colorado, Mr. Neguse, would make revisions to Title V of the Code, which relates to the government organization and employees, to account for three important government accountability laws that were adopted in the 1970s, the Federal Advisory Committee Act, the Inspector General Act, and the Ethics in Government Act. Since these laws were adopted after Title V became positive law, OLRC has placed them in an appendix to Title V, which made citation to them awkward and confusing. In H.R. 5961 eliminates this appendix by creating three new chapters for these three laws within the body of Title V itself. The second bill, H.R. 5982, introduced by the gentlewoman from Minnesota, Ms. Fishbach, would make revisions in Title 51 of the Code, which covers national and commercial space programs. Since it was created as a positive law title in 2010, Congress has adopted several important reforms to the subject matter of Title 51. Some of these new laws were placed into the non-positive Title 42, covering public health and welfare, while OLRC located others in notes to Title 51. H.R. 5982 incorporates these recent statutes into the body of the Title 51 itself. I want to make it very clear, like the other codifications bills, we have considered the statutory changes made by these bills are purely technical. They do not change the meaning or effect of the existing laws. They are simply part of an ongoing effort to maintain the code as an authoritative, accurate, and accessible source of federal law. I want to thank Mr. Neguse and Ms. Fishbach for introducing this legislation. I urge all members to support the bills. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Madam Chair. We appreciate the OLRC as well and support these two bills that make technical changes. Yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. Are there any amendments? With that, reporting quorum being present, the question is now on reporting the bills and block favorably